you get my text I just sent you? Savvy. Oh, Busy, you don't have to drop down as listener. If anyone wants to come take a mic, we have exciting news today. And Mark Basil is going to be coming on shortly. And I'm excited because then he can discuss, the tweet that I put out earlier was I reached out to him and, he said that this is in order to the beginning of the investigation will, even though I know we just heard on the last space that maybe it's the end of it because it's a Wells notice, but they actually, I did send you so Savvy, it's showing you as a co-host. You might need to leave and come back. Can you hear me, Savvy? Let me see. Invite that Busy. Savvy, can you hear me? Let me just text her. I don't think she can hear me.
Yeah, I show her as a co-host. Maybe she needs to drop.
She's not hearing me, and she's asking me to add her.
Savvy, are you there?
Oh, I have to kick her. Hold on. So I'm not literally kicking you. Just gonna remove you.
Oh, Anna, you rookie.
Oh, I'm trying.
And also, can you edit the title, please? I sent you a text.
Yeah, I thought I was texting you.
Savvy, you there? Can you hear Anna?
All right, I'm sending her a co-host now. Let's see. So I sent it. Maybe if I add her as a speaker first, it sometimes works.
You got Mark. And also,
All right.
Savvy, I see her as speakers. Savvy, can you hear me?
Savvy, can you hear me? Could you give a thumbs up or a thumbs down? Let me text her. Sorry. Thanks, Mark, for coming on. I just want to get Savvy up to the mic. Hold on. I still show her as a
Go
okay,
ahead.
I'll cancel co-host and
Yeah,
then
go ahead.
I will.
Add me as co-host. Go ahead. I'll bring up Mark.
Okay.
He only has limited
Thanks.
time.
Thanks, Busy. Let me see if I can get Mark to come up to speak. Okay. I don't know. My space may be glitching, Busy, because I sent out speakers to Mark. And can you send out the speaker invite, Busy? Because I might be glitching.
I just did.
Okay. Can everyone hear? Can I get a thumbs up if you guys can hear us? Winston, can you give me a thumbs up? Jennifer? Okay, good. Thank you.
Hey, Mark, I just sent you a
Thanks, Barb.
invite.
He may not be able to come to the mic yet. Maybe Savvy's going to come back too. Let's see when she gets back. Invite to speak. Can someone request a mic and just make sure that the mics are working? Just to test. Oh, Mark, can you leave and come back? Because I'm getting requests. Oh, Mark can't request right now. Maybe Mark's tied up and he's just listening. Okay, he might not be able to talk just yet. Oh my God, the requests are going crazy. Okay, guys, y'all are amazing. Sorry. Oh my God. Woo! That's hilarious. Whoa. And they're all shifting. Hey, Winston. Winston, can you speak? Can I hear him? Maybe it's me. Okay, now I hear Winston. Okay. Hey, Mark.
We got it. Go ahead, Mark.
Yeah, sorry. I just had to go pick up some keto peanut butter cups for my wife at Target. So I'm just in the
Thank you
car.
so much for coming on and for getting back to me on my text earlier. I was hoping maybe you could share with the community what you put in a text to me because I actually think this is great. It's the beginning of the end, but maybe I'm wrong.
Well, a Wells notice, first of all, is not a mandatory thing. There's nothing that requires the SEC to send a Wells notice. So look at it this way: a Wells notice, by definition, is when an enforcement action is going to be brought against an issuer or its principals. They were given a Wells notice. But a Wells notice can mean something more than that. The actual charges or issues are inside the Wells notice, and we don't know what those charges or issues are, right? And there could be wild speculation. It could be anywhere from maybe there was some information that wasn't accurate that somebody complained about, and they could be looking into that, or as I kind of think that it's more going back to the very beginning, like I had said from MySpace calls, when I was participating with you guys. It goes back to the beginning. We're going to transaction with Meta, and they maybe try to find if there were short positions there. Going to look into how MMTLP started trading with all of the intricacies and was because they don't know if anybody in Meta had anything to do with getting them listed. Although I think they already know their answers. And then um, if there's shorting that occurred in the MMTLP security right before the U3 halt. Now, I don't, you have to remember, I think there was an SEC investigation opened up a year and a half ago. So it's unlikely that this Wells notice is tied into that because other stuff would have happened in between. Now, I'm not privy. I represent John in another matter. I'm not his attorney on this, and I have never spoken to him about this. But in all indications, it's either they're looking at possible misinformation on some type of transaction or some type of publicly released statement, whether it's a press release, a 14A, an S1, whatever the case may be. We don't know, but I wouldn't panic at this point because we don't know what it is. And, the more you speculate, the more you're going to go down the rabbit hole. And there's going to be a whole faction of the community that says, I knew it, they did something wrong. And there's going to be the other faction of the community that's going to say, well, it could be this. And you guys shouldn't be saying that because we don't know what it is. So, if people want to become real leaders, they're going to take a very ambivalent approach to this and look at, possibility is what it could be, but you can't say for certain what it is. So a Wells notice is sometimes provided to give notice of, to the people who are being investigated, but it doesn't mean they're being investigated for anything that they may have done. The investigation is to bring charges. We don't know if it's going to be the individual subject to the Wells notice, if there's going to be any enforcement action or any charge. So it could be. We don't know. I don't know, and none of you know. So if you want to go into somebody else's spaces and hammer the management, if you want to go into another space and hammer the issuer, or if you want to go into another space and hammer FINRA, by all means. But you know, Anna, you run a very straightforward, you and John have very straightforward, even keeled spaces. And that's all I'm trying to bring to you is to don't knee jerk reaction. We're eventually going to find out. In the meantime, there's a whole bunch of other issues that the MMTLP community is going through. So we don't even know what the basis of the Wells notice is. We know it was provided to John and it was provided to George, and we don't know what the basis is. It could be provide us information on the merger, provide us some communications. What were your communications with your accountants, with your lawyers, with your investors? Blah 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 blah. We don't know. It could be just about anything at this point. So keep an open mind. And there's going to be people who's going to are going to think one way, and there's people going to think the other way. Don't let them sway you because nobody knows the truth. And that's basically all I can provide to you at this point. That's all I know.
Well, Mark, can I just, I guess how I kind of look at it is it's what we've been asking for. I know it's an investigation into that's what we're seeing, but it's an investigation into MMTLP and MMAT and Torch, and it's opening up where they're going to. Do you think that this will mean that they're going to look at the whole picture? Because I don't think that they're going to let all
Well, probably. I
65,000
mean, they're
people
probably
like. So it'll give us transparency.
yes.
Do we?
Eventually, once we know, look, if they bring in an enforcement action, it could be against the individuals. It could be against a broker. It could be against a hedge fund. We don't know. We don't know the operative facts behind this. If you read like the definition of a Wells notice, it gives notice to people who are about to be charged, but that's not necessarily factual, and it doesn't mean that those people are about to be charged. So I wouldn't jump on. I'm not, trying to shed cover or sugarcoat this or anything, but we don't know the facts. But it's like a shock. I could understand the shock to the community. It's almost like coming out of left field. Maybe a few people expected it. Maybe there's some things that need to be explained. This is the opportunity to give them to explain things. They're all going to hire lawyers, or the lawyers are going to be, very sophisticated, securities, white collar crime, kind of attorneys. Not saying that there's any white collar crime or anything, but these are the high powered attorneys that are now going to come in and work and cooperate, with the SEC and with the named people, and we'll see what happens. We'll see what it is. I don't know enough to even opine which direction, but maybe this is a kind of blessing in disguise, because one way or another the community is going to get to the bottom of things, and maybe this Wells notice has nothing to do with what happened to MMTLP and the creation of MMTLP, and then the U3 halt. So it's interesting. So I again, I don't know what it is. I'm not privy to that, and I'm sure that they're going to keep it close to the vest until such time that they fully cooperated and shared information, and people can make an assessment, and then the community and the shareholders will find out what's going on. And that's usually the process.
Thank you so much, Mark, for taking time out of your evening and coming on. I don't know. I'm hoping you have time for some hands, and I'm going to give first privilege to the co-host Savvy, and then I think it was Swing and 100.
Thanks, Anna. Sorry about that. I was having problems. I had to restart the phone and all that stuff. Hey, Mark, so glad that you could join us. I just wanted to read a couple things just for some clarity for everyone who maybe hasn't had a chance to read through it. But in the 8K, it says a well notice is neither a formal charge of wrongdoing nor a final determination that the recipient has violated any law. It allows the recipient the opportunity to address the issues raised by the enforcement staff before a decision is made by the SEC on whether to authorize any enforcement action. So Mark is 100% correct. It does not necessarily mean that they will file an action, and it doesn't mean that they won't. Also wanted to let you guys know that indeed, as someone said in the previous space, yes, a Wells notice is sent at the end of an investigation into securities law or regulatory violations. But Anna, you called me and you asked me what my thoughts were, and they kind of echo Mark's. I don't want to make a judgment until we have some more facts, but here's just a couple of my thoughts. Number one, if John Brda, George, or Meta did anything wrong, we should know, and they should be investigated. However, what, according to the Wells, the laws that is referencing in this Wells notice, still has nothing to do with the fact or the assumption by our community that we were defrauded with counterfeit shares. It does not change the fact that market makers made those counterfeit shares, brokers sold them to us, and FINRA halted it so that they could not be settled. John had nothing to do with that. George had nothing to do with that. So I just wanted to remind the community that circumstance does not change. And if indeed this is a move by the SEC, which I don't know that it is, but what Patrick Byrne described, it doesn't change those facts either. And so, yeah, just wanted to remind everyone of that. Sorry, Anna, who was next?
Oh, thank you, Savvy. Yep, it was Swing. And then
Yep.
100.
Just to reiterate exactly what Junk just said, I had posted it up on the Nest. The Wells notice comes out at the end of the investigation. Remember, they just hired their new chief legal officer, and they hired Uzi Metamaterials. By the way, I'm not talking about NextBridge. So the chief legal officer completes the documentation. They submit the AK. The CFO signs off on it. But it comes at the end of the investigation. Now, Metamaterials has 30 days to respond to the Wells notice. And in my personal opinion, I'm bullish as hell on this because I think we're actually coming to the end of what we've all been dealing with for this long. I think this is the proof is in the pudding as far as I'm concerned.
Yeah,
I don't
agree.
think.
Yeah, I agree.
That's all.
Thank you, Swing. I agree with you. I think that this is, there's a light at the end of the tunnel. It's every day we get up and we're, busting our brains just to try to keep ahead and push forward with our voices and our movement. And I'm excited. I feel like at least there's something on paper that's coming forth that they're investigating into this. So I'm hopeful. Okay. Hey, 100, thank you for coming on. Come on, go ahead.
Yeah, no, thank you for letting me come up. I first off, I just want to thank Mark for all his work and just reiterating to stay calm and that we don't know anything about what is going to be on a potential complaint that is maybe coming out or not. So I wanted to come up to express two things. One, I do not trust the SEC at all. I never will. I have a form of PTSD. I will admit that when it comes to the SEC because of many years battling and seeing them not addressing this naked short issue. So I'll get that out of the way. But in terms of where we are in regards to resolving this matter, I am cautiously optimistic. There's a lot on the table. This is another form or path towards discovery. That's how I see it. It's a necessary step. Unfortunately, the SEC does need to get involved. So hopefully they will be held accountable for everything and anything that they do. And I hope that they play it the right way. I hope that Congress doesn't turn and shift focus, especially the ones that have made public notice that they've supported that there is an issue here, and that will remain to be seen as we continue to address Congress in our campaign. I also want to just reiterate that throughout this process of learning or just experiencing all the different challenges that are involved with fighting this war, just as an investor and meeting professionals in the industry, I just like to say that this is part of that growth process. And as uneasy as I may feel about it, I have to admit that, and I have to express it to everyone because I know this is, for many of you, this is your first time. This is not my first time. This is like my fourth time in some capacity. So it makes me nervous because for obvious reasons, but at the same time, I also see that there is a somewhat synergy to this where You cannot allow this alleged crime to be swept under the rug anymore. It does need to be addressed, and there's enough evidence to prove that if the SEC approved the S1 originally, they're on the hook as well. So they have to address it too. So anyway, I just wanted to thank everyone and appreciate all that what you do.
Well, now you know why there's a lot of your FOIA requests were denied. Just remember that.
Yeah.
So maybe, Mark, what we do then is we wait and see for 30 days and resubmit those FOIAs. Because indeed, if they charge, would that be the investigation coming to a conclusion?
The investigation would come to a conclusion and would start the enforcement action. But because it's an ongoing enforcement action, your FOIA request will probably be denied as well.
Okay, that's good to know.
Yeah.
Yeah, I just kind of want to chime in on what 100 was speaking about. We have to continue to push forward just like we did today and every day since this began, because we don't know what the intentions are behind this. We're all hopeful that this is going to be to actually get true transparency and that they're done covering up for FINRA and for the broker dealers, and that they're actually, the government is going to step in now because they've heard from so many of us. But we've got so many contacts now in Congress that we need to continue to nurture those, because just like Savvy said, this does not negate the fact that, we were sold counterfeit shares and that we can't transfer our shares to AST because, well, they're not even giving us a reason, right? So we need to continue to push Congress and to nurture those relationships, to ask that they're, seeking the numbers from the broker dealers, from FINRA, from the SEC, from any angle that they can get it is what we need to be pushing for, and to continue to support Pete Sessions and to put out public statements that they're wanting transparency for us. So let's just continue to fight. Okay, guys? And Ace, go ahead. Ace, can you hear me?
Okay, yeah, I had a quick question. So I guess the way that I kind of look at it as like the SEC is basically the police department for basically the securities, right? So it's almost like if you have your local police department, the people in the community are calling this police department, reporting all kind of serious crimes, but that police department's doing nothing. So let me just get straight to the point. Basically, I kind of wondered, I guess kind of rather, because with securities, there's thousands of them, right? This is one ticker, just one ticker, but typically people have a diverse portfolio and they may have, 20 or 30 or 100, whatever securities. So my question is this. The SEC, they're not even handling basic things such as, for example, enforcing like your failure to delivers, threshold, as far as like the threshold list, they're not even maintaining the threshold list. So my point is that has anybody ever, like, I guess rather than going through the approach of literally basically filing a court case, I guess per se, for each ticker that you're having an issue with, which that doesn't seem like it's too successful, because it's almost like you file a whistleblower report or a complaint. And as far as, I guess this is another question. So from a performance perspective, so say, for example, does the SEC get like 1,000 whistleblower, basically 1,000 complaints for various tickers? Are they handling 10% of them, like 100? Because if that's the case, are they shorthanded and they need to hire more people? Because it's almost like the root of the problem is not getting taken care of, because it's like you can file a whistleblower report or file a lawsuit or whatever, and they're like, okay, we're working on it. and it just sits on the desk and collects dust. So I guess to put pressure on the SEC, whether it be to sue them, to get requests for basically prove that they're not fulfilling their basic responsibilities, which, like I gave some examples, failure to deliver. I mean, this insider trading and all this naked short, that's a little more advanced, but they're not even covering the basic stuff. So this seems like a decent argument that these guys are not even attempting to do their job. Do they need more manpower? So has that been addressed okay, they're handling 50 tickers a year, which they're responsible for 1,000. So obviously that's not adequate. Yeah. Okay.
So there are numerous SEC field offices, and my firm has dealt with a lot of them on different issues, um, especially in the whole dealer registration world. But I can tell you that the enforcement attorneys at the SEC I spoke to are very busy. They are handling a lot of cases, and they're actually, you know, you don't see it from your side, but I see it from my side. They all do excellent work. They don't bring a case unless they can, 99.9% of the time prove their case. And that's why a lot of these SEC enforcement actions against these unlawful fundings that a lot of NASDAQ and New York Stock Exchange companies have are not, or, just starting to ramp up because they're starting to enforce these laws. So are they shorthanded? There's, like you said, there's probably 10,000 tickers between all the exchanges just in the United States. How do you monitor that? How do you get ahead of that? Like, there are whistleblower complaints, shareholder complaints, they write them in. Then these things are reviewed at a certain level. Then it goes to committee. The committee then decides whether or not they want to start an investigation. If they start an investigation, nobody's supposed to know about it other than the target of the investigation. They get served with administrative subpoenas. They may take depositions. And then once they have all their data, then they usually bring an enforcement action. But I mean, it it would be next unless there's some sort of AI that can be developed for the Securities and Exchange Commission in real time to monitor all this and spit out all the crap that's going on. Um, it's an insurmountable job. And I know, like 100, and they're very suspect of the SEC, but the guys I've spoken with, I'm not talking about management or the directors or anything, they have their jobs to do. But the enforcement attorneys I speak with, very knowledgeable, very hardworking, overworked. That's why sometimes investigations take, 2 or 3 years before you start seeing something like a sales notice or an enforcement action. So yeah, Ace, they are a little backed up. I think they're probably updating some of their technology to get a better handle on this because the markets are moving faster than they can, right? And the markets are really moving faster than FINRA can oversee as well. So especially now with blockchain and everything else, it's a very trying time. And I'm not defending them, but but the cases that I've seen them investigate and bring are really good cases, and they get to the bottom of things, pretty quickly. In fact,
Yeah.
I think they just sued Savvy for naked short selling.
Yeah, I was
So
just going to give one quick example, and thanks. One quick example is parking tickets. So, which that's very petty. So you can go out here and get 100 parking tickets, but they have court dates. Court dates. If you do not pay them and tear up the tickets, you have a court date. So there's a priority to get this parking ticket taken care of immediately. But this whole securities fraud that's taken place, that's actually costing us investors a lot of money, which is more a more legitimate, I guess, issue or incident than a parking ticket. The priority level is low, so it's not taken care of. So I guess that's kind of my grievance. Some escalation needs to take place because us as investors, we are impacted. Because and I'll just wrap it up. Yesterday morning, for example, I was trying to close out a position, and I literally had to basically close it out in several transactions because my transaction was basically sitting out there, I guess, due to the size or whatever. I'd just say it's manipulation because when I broke it up into smaller, I guess, sales, for example, like 6 different sales, I was able to quickly. So that's just some simple example. But my point is priority. So some pressure needs to be put on these people because it's costing us money. Like I gave you the example where it took me 30 minutes or so to sell a position. So I'm losing money because obviously the stocks, it's not trading sideways, it's coming down. But anyways, okay, thanks.
you may be onto something. Sorry. because they have immigration court. They really should have securities court, which is a separate court system where you have judges who understand the securities markets and all the crap that goes on there. And that may be something that, is in the future, because it's just such an enormous market with an enormous potential for fraud at so many different levels. It's almost look what happened to you guys. It's almost mind-blowing on all the crap that you guys actually have some indication of what happened.
Exactly.
But you still don't know what happened behind the scenes. I think you need a sophisticated court system to deal with the securities market. So
yeah, because I lost like 20% yesterday because the thing wouldn't process. Anyways, okay, thanks.
Well, you know what? Instead of giving Ukraine $20 billion, maybe you can ask Sessions to pass a bill to start securities court in the United States. That's a good start. So
that is. Thanks. Okay.
Thank you, Ace and Mark. That's a great suggestion. It's something we can discuss with Congress. Savvy, go ahead. Co-host privilege, and then JJB.
So Anna, that tweet that you sent me, I have put up in the nest. Mark, what I just put up there is a detailed list of the complaints from the SEC to John, Meta, and George. So they are very specific. There's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So I don't know if we want to look at those individually or just wait and see till something is filed. But I did put that tweet up in the nest. It's by George Jr., George, Joeojr. But it does go through section 17 and hit all of the points that were mentioned in the Wells notice.
Okay. Yeah, I have to get off the phone now anyway.
Okay.
So, but I'll take a look at it later tonight. If we have another session tomorrow, then maybe I'll jump on and I'll go over it a little bit more with
Well,
you guys.
I will be there tomorrow morning, so you are welcome to come and talk about it then. And then, Anna, if you want me to read them out to the community, I'm happy to do that. If you want to continue that discussion after we go to the other hands, just let me know.
Oh, I would love that. Thank you, Savvy. Hey, Mark, thank you so much. You are just thank you so much for everything you've done for this community. We are forever indebted to you. So I'm just appreciative and very grateful that you've been here with us in this and guided us. So thank you.
Well, it's not over yet. So we'll see what happens.
Yeah, not over yet, guys. We got to keep going. But we have, 30 days to respond. We know that there's wheels in motion. And I think that it feels good to know that there's something going in motion.
Yep. All right, guys. Don't panic and have a good night. Okay.
Thank you, Mark.
All right. Bye-bye.
Have a great night. Go ahead, I am. Or I'm sorry, it was JJB. I apologize. Go ahead, JJB. You were down below and then it popped up. I apologize. Go ahead.
That's all right. Can you hear me okay?
Yeah, I can hear you fine.
All right. 100, you still there?
Yeah, I'm here.
I kind of feel what you're throwing down, and I got this. I'm just going to address the elephant in the room, and I've got this pit in my stomach. For 6 months, 7 months, 8 months, however long it's been now, who knows? We've been talking about this. This shouldn't have been trading. This was illegally trading. What is your opinion on the SEC sending paperwork to these two guys saying, you're absolutely right, this was fraudulent, it shouldn't have been trading, everybody that bought a counterfeit share will get their purchase price back, it's counterfeit, you don't get your NetSprig share, that's our ruling, life goes on?
To be honest, it all depends on their intent. What they put in a formal complaint on the docket is really what matters. So if their intent is to address the issues with the merger and not go after the issuers or individuals that are involved with that merger, if their intent is to expose that there was an imbalance of shares and all of the market participants and negligence that may have been involved, that remains to be seen. So yeah, I say that I'm cautiously optimistic. And you have to understand, this is like me going through deja vu 12 years ago when the SEC goes after a group of nefarious actors with what they show to be nefarious actors, and they totally disregarded that there was ineligible shares that were trading electronically in the stock market. Same situation as MMTLP, but they decided to go after the other matter. So when Mark Brazil comes in here and he says they have they have a pinpoint way of investigating and they do a good job. Yeah, they do a good job, but it's in regards to their intention. Like, where are they going to focus their intention on? That's my biggest worry. So until I see it in print, I'm not gonna feel satisfied. I want to see what's in print on that, what's on that docket, and that's what I've been saying since day one, since I came into the community. A judge is the one that's going to have to decide this, and if the SEC does the right thing, then this is their opportunity to change their reputation and really defend retail investors. If they decide to protect Wall Street and its bad actors, we will find out very soon. So we'll see.
Awesome. Thanks, 100. Appreciate it, Anna.
Thank you, JJB and 100. I just kind of wanted to chime in on that. The SEC has a terrible reputation. So we need to continue to push Congress and say, listen, the SEC just put forth this Wells notice to investigate John Brda and Palikaris, but are they going to be investigating FINRA and the hedge funds and the market makers that's, were suspected to get this trading? So are they targeting to protect FINRA? So we need to, make sure that we're pushing Congress that they're going to be pushing the SEC to do the right thing as well, right? Because they can't just investigate one side of this. They have to investigate the whole situation.
Well, Anna, I don't. Maybe I heard Mark wrong, but with them getting the Wells notice, isn't this the way the SEC says, "Hey, issuers of MMTLP, John Brda / Palikaris, we've completed our investigation, and this is our findings." So is that the way it is? I mean, they're done with their investigation,
But
correct?
John Brda and Palikaris weren't the issuers of MMTLP. They weren't the ones that got this trading.
No. They're the ones that had the complaint. That's what I'm saying. We don't know what this paperwork says, but hypothetically, it could say, "Hey, ABC, yes, did this illegally. We're letting you know. We're going to find the what out of them, and this is what we plan to do to make your shareholders right." I mean, that's just a shot in the dark.
You are 100% correct, and that's how I see it.
Thank you, JJB and Swing. Go ahead, I am.
Hi guys, I'm a shareholder since like 3 years ago, 4 years ago. The only thing I want to say, you guys, you have to keep in mind when like 3 months or 4 months ago, when Mr. Cromwell, I think is the chairman of FINRA, I believe.
OTC market.
OTC market, yeah. What he say? He said the resolution for the problem, next bridge need to go to the public. I believe they will do all what they can to make the next bridge hydrocarbon to be public. Yeah, just keep in mind what he say, you know what I mean? Because now they are under investigation. Mr. Cromwell, he gave us already the resolution. That's what I think. Anyway, we wait, we see what's going on, I don't know.
Thank you, I am. Rob, go ahead, and then I'm going to see if Savvy's ready to read. Go ahead, Rob.
Hey, always some interesting news on these spaces. I was just thinking, do you think that this entire maybe investigation, and this is kind of like being abstract, could this have been prompted maybe by all of our calls to the OIG Office of Inspector General a few months ago, and maybe somehow it's involved with that? Just a question.
I think it's a accumulation of all of our efforts.
Yeah,
and I think that they're feeling the pressure from Congress, from our community, from the 10 billion impressions that we've put forth.
Yeah.
I think they're hearing us, and they have to put something out, and they're finally investigating. Go ahead, 100.
Yeah, awesome.
I think it has to do with the amount of liability that they cannot get away from. So they have to address it, and this is their formal process of addressing it. I just hope that their intention is the right one.
I hear you there. Thanks, you guys.
Thank you, Rob. Savvy, are you ready to read?
Sure. So, guys, again, this tweet is up in the nest. But for those of you that, for whatever reason, can't access it, I'm going to go ahead and go over it. These are the actual sections of the Security Code of 1933 and 34 that were referenced in the Wells notice. So first of all, section 17A. 17A makes it unlawful to, quote unquote, employ any device, scheme, or artifice to defraud, obtain money or property by using material misstatements or omissions, or to engage in any transaction, practice, or course of business which operates or would operate as a fraud or deceit upon the purchaser. Anna, do you want me to read them all, or do we want to read one, discuss, and move on to the next one? What do you want to do? You the boss. Anna?
Sorry, I was reading along with you and then I was trying to get back.
Oh no. Do you want us to just discuss one at a time, or do you want me to read all of them?
It's best to read them all and then we can kind of go over it then. Okay, that'd be great.
Okay.
Thanks.
Section 10B makes it unlawful to use or employ in connection with the purchase or sale of any security a manipulative or deceptive device or countervalence in contravention of such rules and regulations as the SEC may prescribe. Section 13A of the Exchange Act requires all issuers with securities registered under Section 12 of the Exchange Act to file such periodic reports as the Commission shall prescribe by its rules and regulations. 13B 2A, make and keep books, records, and accounts which in reasonable detail accurately, fairly reflect the transactions and dispositions of the assets of the issuer. 13B 2B, devise and maintain a system of internal accounting controls sufficient to provide reasonable assurances that 1. Transactions are executed in accordance with management's general or specific authorization. 2. Transactions are recorded as necessary to permit preparation of financial statements in conformity with general accepted accounting principles or any other criteria applicable to such statements. And 2, to maintain accountability for assets. 3, access to assets is permitted only in accordance with management's general or specific authorization. And 4, the recorded accountability for assets is compared with the existing assets of reasonable intervals, and appropriate actions is taken with respect to any differences. And Section 14A of the Securities Exchange Act of 1934 prohibits material misrepresentations and omissions in proxy statements sent to shareholders of registered securities. Section Rule 10B-5 states that it is illegal for any person to defraud or deceive someone, including through the misrepresentation of material information with respect to the sale or purchase of securities. SEC Rule 14A-9A. This rule applies to omissions or misleading statements in connection with any tender offer or request or invitation for tenders or tenders, I guess that's the plural, or any solicitation of security holders in opposition to or in favor of any such offer, request, or invitation. Regulation Fair Disclosures, Reg FD, is a Securities and Exchange Commission SEC rule designed to prevent selective disclosure by public companies to market professionals and certain shareholders. So that's it, guys. That's what the Wells notice is referencing.
Well, the first thing that came to my mind is they used 12-year-old financials to get MMTLP trading. So a portion of that definitely, I think, kind of addressed that. Any thoughts? We have a hand. Mimi, go ahead.
Hello. I would just like to say that these Wells notices come at the end of an investigation. So it means that the investigation has already happened, and these are the charges that they may plan to they may charge with those with what Junk Savvy just said. So I just think that it would be it's great to think that it's about this, that, and the other thing, but what we know so far is just that John Brda and George are being, have been investigated for this, and that the SEC is prepared to possibly bring charges. And that is it. That is what we know from what the information they've given us. So I just think if people could be mindful about speculating that it has to do with this, that, and the other thing, when the facts that the SEC revealed are just that John and George are being investigated for all of those things Junk Savvy said.
Thank you, Mimi. Go ahead, Mike.
Thank you.
Mike, welcome to the mic. It's your turn.
Hey, okay. When I was reading that through there, what the words that jump out to me, I don't know if it jumps out to the rest of you, is the word deceit and fraud. And the other part implies people didn't keep up with the books or the numbers, what it appears, and that in the let's see, and then it talks about in the 13B that the fairly accurately and fairly reflect the transactions and dispositions of assets. Well, when they started issuing MMTLP, you're supposed to have, I guess, enough money to back up what you're putting out. Correct me if I'm wrong, there has to be some sort of basis of money. So if they just started doing this without any, money to back it up to start with, that would be fraudulent or whatever. But I see several things that make me. You see words like misrepresentations, fraud, deception, different things, manipulative or deceptive device. It's so throughout the whole thing, if you'll notice, it uses those words. So I got a feeling it's going to be opening the can of worms we need opened.
Thank you, Mike. I always appreciate hearing from you. Winston, go ahead.
Yeah, no, just a couple really quick points. With all of the talk about deception and the issuance of MMTLP and how it was traded, I mean, if you think about this in any other context, so say someone else started something trading and they said Elon Musk's name was behind it. That would, his name alone carries an implication and an implied value to pretty much many things that are trading out here. So not saying that he's involved in this at all, but I'm just saying if you think about someone else's name being used as a source behind a security trading and that not being the actual true identity behind it, that's the definition of manipulation. So I'm hoping that this is just continued progression in a direction and getting us closer to that finish line and closer to facts and things actually coming out. That was all I had to say.
You know what, Winston? Ironically, the example that you just used, the richest man in the world became that way because he was fighting naked short sellers. And he was fighting the SEC at the same time. That's what's ironic about it.
Truth.
Yeah, and Costa, thank you for that. He's in a restaurant, I can't speak, but he wanted me to mention, this was a preferred share dividend that was never meant to be traded, right? And they used old financials to get it trading. So you know, as we know that that's the truth, the SEC is going to discover that because Brda and Palikaris, that's their story, that's their statement. They, that's what happened. So that's going to be exposed, hopefully. So thank you, Winston. I appreciate that, and thank you, Costa. I think it was, well, Savvy's the co-host, so first, and then I think it was
No.
Halia and then Mike.
I'll wait my turn. No, go to the others.
Oh, no, go ahead, Savvy. You're the
No,
co-host.
no,
Go
no, no,
ahead. All
no.
right,
Please go
Halia,
to
go
the
ahead.
others.
Well, that's very nice. Go ahead, Halia. How are you tonight?
I'm okay. So, listening to the rundown of the charges, I'm thinking that the manipulation and fraud is if you know you only got 165 million shares and you open it up for trading and there's only 165 available, you're overshooting your assets by putting them out there. And they probably want to know, where's the money at? Where's the money at for all these shares that you've been selling? There was a backdoor to a dividend that was not supposed to be traded or sold. So what it boils down is somebody got some explaining to do, and all they need from John Brda is a handwriting sample.
Thank you, Halia. Savvy, did you still want to say something?
I do, but Mike, do you still have a comment?
Yeah, I just wanted to make everybody think a minute now. If this is supposedly directed at Meta and John Brda. If I was, what is the best thing to do when you're not guilty of something, or the best is, what do you try to do? You try to get out in front of the situation, and so what Meta or George, for a better word, I guess, put out the 8K when they didn't necessarily have to say anything. So, with that thought in mind, understand they're trying to get out in front of it. They know what the stuff is as far as the stuff we don't know, aren't privy to. And so they're just trying to get it out in front of the shareholders. And so if they were nefarious anyway, I can promise you, if Meta thought they were guilty of anything, they would never have even said anything about it, in my opinion. So that's just what I wanted to add about it. They're trying to be in front of it. They're trying to be open with the shareholders, and they're trying to let us know that what's going on, and when they really didn't have to.
I would agree. That makes a lot of sense, actually.
But guys, I'm sorry. Let me reiterate before I take a bullet. I'm going to take a bullet because I know some of you are thinking this because you have reached out to me. But I want to say that no matter what is happening with the Wells notice, it does not change the fact that George or John or Meta or Torchlight created the counterfeit shares that we were sold. They didn't create them, they didn't sell them, and they did not halt the process that put us in the circumstance that we are today. So I do want to say that.
Hey, Savvy,
Yeah, go ahead.
real quick before you go, read your text and then Anna
I did.
and you guys decide if you guys want to put that out.
Yeah, Anna, you go ahead. If you look at it, I saw it already. But here's what I'm going to say. I am not original torch holder, but torch is mentioned in this Wells notice. I've heard lots of discussion that George pumped this stock. Is there any space in your original torch holders' minds that this could be referencing George's behavior around the merger with Torch, the promising of the sale of the assets, all of that stuff? Because even though I am not a torch holder, was not a torch holder, I'll be honest, reading that, it's what was coming to my mind. Now, granted, I've had several conversations with multiple people recently about that situation. We know that there are nefarious actors within our community that have been pushing the narrative that this has all been John and George's fault. Wouldn't surprise me if they are in communication with the SEC, one in particular. So just, again, want to make sure that we are looking at this in a balanced and fair way. I don't want us to, force down one narrative and leave out, those other thoughts. So just want to put that out there, see if anyone has any thoughts or comments on that in particular.
I do. I can tell you straight up. 12 years ago, it was the same situation. They went after the issuers. They went after individuals who they thought that were stock pumping. They ignored the naked short position. And here we are today where the disclosure statements of the company are still published on the OTC markets, and the stock is trading on the expert market, yet still no resolution. But the SEC put out their complaint against these actors, and then years later, they were found that because of their practices, they were unconstitutional. So it's bittersweet here. Like, it really does depend on the SEC's intentions here. If they're going to go and play that same game, then this is going to be an issue. If they're not, and they use it as an opportunity to right their wrongs, then it's going to look really well. So we have to see what's in that complaint.
Well, and N100, for Mark's words, we have to see if they actually file one. This could just be a way that they're going to close out their investigation to get George and Meta's and John's point of view. But I think that if we're being fair and balanced at all, we have to be prepared that it could be actually about George and John as well. There could be some complaints and charges filed. So I just want everyone to be prepared. Not that that's what I hope for. I don't. Again, I was not around in the Torch days, so I don't know what was being done back then, but Torch is mentioned in the Wells notice. So it appears to me that it's going all the way back to Torch days.
Yeah, I don't disagree with you at all. It's obviously gonna go to its history, and that's what it should do. Again, another path towards discovery, which was necessary since day one. I take a deep breath here because, all right, the hell with it. Since February, I've been giving intelligence to John Brda. And the information that's been given to him in regards to all the trading and activity with naked short selling, giving him evidence any which way, it's only to support that there is a naked short position here, and it was the fact that you had fraud. So if John Brda was taking a risk back then, trying to gather all the evidence and defending his position, even to this day, then I support him 100%, because I believe his heart and his attention is in the right direction. So if the SEC wants to come out their face and they play this the wrong way, you know what? If they try to do it, they're gonna have a lot of headaches in the future, because I myself, and I'm not trying to be egotistical here. I'm stating a fact. I'm a witness, right? I have financial records from my broker stating that there's a naked short position with E-Trade. Okay, I'm a witness where I own stock that should have never been traded, and I have physical certificates, and I have verification and registration from the transfer agent, and I have records that I purchased stock after it was suspended, okay, and put onto expert market. It's still trading. So the SEC can play this game all they want. If they do this the wrong way, they're gonna look really bad. So I'm nervous about it. I'm cautiously optimistic about it, but I will not believe anything until I see what's in print.
I think that's a good rule of thumb. We really cannot trust the SEC on this. We have called for 8 months now, and they've given us really nothing. So I think, this is really more of a time to up our game. We need to continue to call on Congress to demand transparency. The SEC really cannot be trusted. So, I think it's important, the case that 100 just brought up, I think we should bring that to Congress and let them know that they've done this in the past. And so we're worried that that's what's happening again. We need to bring our concerns to Congress so that they don't buy into what the SEC, if they are doing something nefarious here, that we're ahead of it, right? We want to be ahead of this, guys. We want to talk to Congress about our concerns, and we still want to push for transparency so that we get the numbers.
I'm going to put the post in the nest. I'm going to find it. I'm going to put the post in the nest so that everyone can save it, bookmark it, print it out, do whatever you need to do, but reference it just in case you may need it in the future.
I think we need it now. I think we need to bring these concerns to Congress. So, guys, that's going to be another call to action, that we're going to continue to reach out to Congress, about our concerns, and that, still putting forth the letter to FINRA, to the broker dealers, that we want these numbers. So thank you so much, 100. I think it was AK Dallas, and then I'm not sure. I think it was KK Kip. I apologize, guys. I was responding to a DM.
Hey, good evening, guys. I just want to say a couple of things quickly. So just keep in mind that John Brda mentioned that SEC was the one that suggested to fill out the S1 form. S1's, as Rosa mentioned, it's like the Ferrari of forms. It's the most detailed version of NextBridge's business plan. So they didn't have to do S1, but this is what SEC recommended. They could have gone with a lesser detailed form. And then on the nest, I also put a DD thread I did like in January. It's the two law firms that represented NextBridge and MMAT. These two law firms, they were part of the S1 that went back and forth with SEC. They're two of the best law firms that's out there. So if you are interested in seeing which of the lawyers that represented both the companies during the filings, it's on the nest. So the legal counsel that we had during the filings were some of the best out there. So if they're pointing fingers, I don't personally believe it is going to be on John Brda or George. As Mark said, we don't know what the source of the filing is, so I wouldn't be worried, especially with having these two law firms representing both the businesses, and the fact that we filed an S1 instead of any of the lesser forms. We gave out as much detail to shareholders as possible, which was not required at the time. So just something to keep in mind, who were our lawyers and why we did S1 over some of the lesser detailed forms.
Thank you, AK Dallas. Yeah, guys, that's up in the nest. If you guys aren't familiar, scroll up to the top. There's a great information up there. 100's put his tweet out. Sabby's added some tweets. So please, guys, tweet, retweet. Let's, get the information out there. Thank you so much, AK Dallas. Okay, go ahead, 100.
I just want to let everybody know that post that I just put on the nest has a photocopy of correspondence of E-Trade identifying a naked short position. It has a copy of the DTC stating that EIGH was non-DTC eligible, which means it should have never electronically traded. And then it has the correspondence. It has the court record of discovery showing that it's a private company. So, excuse me, I'm out of wind because I just worked out, but yeah, it's there. Anybody has questions, just reach out.
Thank you, 100.
That link is going to 404. So do you mind seeing if you can recheck the link for that?
$100. Did you hear AK Dallas?
Yeah, Danny, that link is showing an error. 404.
Oh, is it?
Click on the picture, not the picture, but like the icon of the link. I don't know about so don't click on the link that's in the tweet. Click on like the Investors Hub.
Oh, you're right.
That.
You're right. Yeah.
But great
I want to
observation,
drop down.
team.
Thank you guys, but sorry about that.
That's another thing Investors Hub does, right? So if you ever, so Investors Hub is a hedge fund bad playground, and I spend a lot of time on that website because I monitor all these nefarious actors, hoping that one day I have to testify against them and bring them to court. So I know that these boards are being monitored by law enforcement. And how do I know that? Because I requested a FOIA and it revealed that the FBI and FinCEN was involved. That's why I've always been an advocate and so positive with strong conviction that there are many things going on behind the scenes from a long time ago, and I've stuck with it, and I still remain that confident. But you know, again, you just have to understand this is so complex. There's so many things in play that, as far as this is concerned, in regards to the SEC, they haven't proven themselves worthy yet. So I'm always going to be suspicious of them until they show the right intentions. And this is part of the reason why I fight every day. And this is why I'm giving you this evidence so that you can see and reference, listen, this is an issue that has happened. You didn't address it. You did the same thing if you're attacking the issuers and you didn't address the imbalance of shares. And it clearly states that there's an imbalance of 323 million shares for EIGH, but you didn't do anything about it. You went after the issuers and you went after the stock promoters and whatever, but you didn't do anything to protect retail investors. So are you repeating the same behavior, or are you really going to step up to the plate and then change your tune and do the right thing? So that's it. I'm so pissed right now. I'm sorry.
Thank you, 100. Guys, I just can't. I'm excited actually I'm happy. I'm cautiously optimistic, but what you just said, 100, is something that we have to get to Congress because, um, you know, we don't know what the SEC is up to. But the fact that, it's a notice to Palikaris and John about their intent when they're not asking about the share imbalance. That's what we have to push for, and I think that we have to get that case that you're involved in to Congress so that we can show them that there's precedence here that it's happened before. So thank you, 100. I think it was Halia. Then I'm not sure, guys. If you guys want to do the honor code here, I apologize. I was responding to a DM.
I'm sorry, I'm a terrible co-host. I have been too, Anna. Sorry.
There's a lot going on. Sorry. Go ahead,
It is
Halia.
how it's Halia, Wasabi, I think Michael, then Kevin.
Thank you, Savvy. Go ahead,
So,
Halia.
what FINRA and them guys would like for us to believe is that John Brda screwed over his friend with the Torchlight deal and helped Palikaris uh, sell us some counterfeit shares. More or less, that's what they want us to believe.
I'm not sure how yet. I think that we don't really know what the intention right now is of the SEC. So I think we just have to wait, um, and continue with our actions to see how it plays out. We're not really sure what the intent behind all of this is.
So, but in the worst case, then we would all still have Next Bridge. Next Bridge would sue Meta and John Brda, and and that's how it all ends if it didn't go the right way.
No, you don't have next version until you're in AST. Until that happens, you own an IOU. That's what it is.
Thank you, 100. Michael, go ahead.
Okay. It's been a day or two, and guys, I just have a couple of thoughts, and I don't want them to be mistaken. But yeah, this is really tough. When I've seen kids, this is just these people, Brda, Palikaris, they may and probably are 100% innocent. I'm not trying to throw any dirt on them. I'm just have a thought as to a different opinion about trying to get out in front of something because you want to, hey, I've done it when I was a teenager. I've seen other people do it. I'm probably maybe the oldest person in this Discord or space at the moment. I've seen it all throughout life. When, especially in a teenager, when you've done something you knew you shouldn't have done, you go run and tell your mom and dad your side of the story before they hear the other side of the story so you can get out in front of it. It's not always you want to get out in front of it so that you squash everybody else. Is you want to get out in front of it to get your side of the story out, but so you can affect or make your parents bias against anybody else that's coming after you or whatever. So just for that train of thought, has nothing to do with this, nothing other than sometimes people get out in front simply because they want their side of the story to be heard before the paperwork comes out or your neighbor tells that you did something and whatever. Okay, that's enough said about that. The other thing is, I remember, it seems like, God bless, June of 2021, in July of 2021, I went on vacation and my son-in-law and myself had bought a shit ton of Torch. I never bought any more out of TD Ameritrade anymore, and my son-in-law did. I did not. I still got them. Still got them. I never bought any more because I went back to the original paperwork that said, hold by this date and you will receive 1-for-1 dividend, and it will be somewhere between $1 and $10. You know what I ever expected out of this for all the Torch shares that I held and I'm still holding them, are that they're now these placeholders? I expected somewhere between $1 and $10. And, you know, it's been 2 years plus. And I mean, I'm not saying all the people that bought it. I had opportunity to buy a bunch too, but I didn't because I was afraid that I didn't know it was going to be this kind of shit show, but I was just afraid that some bullshit, they really wasn't something, you know, and sure enough, I never knew it was going to come down like this, but I just didn't buy any more. Besides, I got a plenty. If it would have paid $5, let's just split it, $5 from the original time, if it would have been December of 2021, from the oil fields and all that, they would have given me $5 for my share. It would have been a damn very happy, merry freaking fucking Christmas. So, you know, I feel like, I don't know who pumped it or even if it was pumped, but it got kicked and then it started trading. And, you know, I had my opportunity to sell it, but then I'm like, I'm wrapped up in the game too. You know, like, hot damn, this is going to the moon. It's another AMC moonshot to 72. I was part of that too. But nevertheless, you know, I got caught up in it, and Lord God, I wish you know, I don't know. But I'm just saying, sometimes people get out in the front because they want their side before anybody else's. And July 21, I was on vacation and we were talking about this. Wonder what our dividend, when we're going to get our dividend. And that's been 2 long ass years ago. And for which, at that point, I would have been happy if they'd split the difference and give me $5. I'd have had a damn Merry Christmas. Thank you for allowing me the time. Good night.
Thank you, Michael. Merry Christmas.
Yeah.
Okay, I think it was Wasabi 21 and then Kevin B.
This may have already been said, but one perspective I had on that was if they received the filing, it's, when the incorporation had John Brda's signature on it, why wouldn't they go after John Brda first? How do they know it's falsified, right? So why wouldn't SEC ask for that? Right? I mean, that's, from my viewpoint, that would be natural, right? They're not going to take his word for it until they actually have it in writing in legal format. Thought?
Does anyone want to chime in on that?
I'll chime in on it. John Brda called the SEC when this started trading. They were aware in October of 21. So
I thought
I don't know.
that he called the OTC markets, not SEC.
Both him and Palikaris both talked to FINRA and SEC, and they basically blew him off and said it's trading whether you like it or not. So I'd like to know how the SEC is going to say, "Oh, Mr. Brda, it's all your fault because you're one of the people that instigated this whole merger." I don't think so. That ain't gonna fly.
Well, I didn't say it was going to fly. I'm saying it's just, a natural proceeding. But to your point, if there was proof of him reaching out to SEC in a trail, that would make it a moot point.
Yeah, because the first thing they said, the S1, this is not supposed to be trading, that he looked in his account and all of a sudden he's got $6 million in his account. His broker calls him up and says, you got money in your account. And he's like, from what? And then if you've been, I'm an OG, I was, and we went through that. And then, he's saying, I'm sure then that the next thing he's talking to George and they're conversing back and forth and saying, what's going on, here. And they called the entities who are supposed to protect their companies and them, and they just allowed these two market makers to start trading MMTLP against their wishes. That's been notated and said. I guess, I don't know, there's videos, there's documentation of him saying it on the record, on YouTube and everything else for, 2 years. And, and Michael, I just like to say to you, the 8K isn't telling the beginning of isn't the company running like the scenario with mom and dad. The 8K is just being open. The story hasn't came out yet to who says what first with the details. So that's how I'd answer that part to you. The details hadn't come out. That's just an opening thing to be transparent, showing transparency to the stockholders. And I appreciate Meta for doing that instead of, because they didn't have to. And so that's just what I'd like to, we got to understand one thing, folks. Go back to the FOIA. Who was FINRA talking to at the SEC? The SEC and both of them knew about it. So that to me, the SEC is not our friend. Okay, like 100 says, they may go after John and they may go after George, but guess what? If they drag them into court, guess what's going to happen, ladies and gentlemen? It's called discovery. They're going to have to open the books and they're going to have to prove their case. And guess what? We are just waiting in the wings for that to happen. I can promise you, Wes Christian's probably just saying, he's probably having a glass of bourbon right now, saying these guys have lost their minds. But go ahead, try to attack my client, try to attack John Brda, and whatever. Stupid is, stupid does, like I say, like Forrest Gump says. And I would just like to say, if the SEC jumps off that platform into that mess, they're fixing it, like 100 said, they're fixing to bite off a whole lot of more that they going to get to chew on. And guess who's going to benefit? Us, because we're going to get the final share count. That's my opinion, and I'm sticking to it.
Not only that, but just the fact that Sessions publicly announced that there was an issue there, and then he displays it in town halls. I mean, and then you have congressional letters backing that up, and you already know the SEC's on the hot seat. Like, you really have to be very, very self-sabotaging yourself and risking your congressional authority by 1933, 1934 by going after the wrong people in this situation. There's way too much liability on the record, way too much. So like, I can't see how this is John Brda and George getting in front of an issue that they committed that was wrong. This is something that was committed against them, and they're fighting like hell, trying to show that there's a problem here. So, I don't like that message. I don't receive that message. I mean, yes, it's the opinion, and I respect it, but there's no way I can accept it, especially if there's so much evidence, not just what's in the public record, but even behind the scenes on Bloomberg terminals, showing that you had equities formed as collateral, and how that was issued. Like, there's just way too much evidence to show here that there was foul work, and that's not something that a John Brda or a George P can do behind the scenes in the financial system. Those are market participants. Those are brokers. That's clearing of unregistered stock, right? That's violation of Rule 144. This is textbook stuff. They are definitely on the hook. So yeah, there's just no way. There's no way.
Hey guys, sorry, I was away from the mic for a minute, and I don't know whose hand was up. I think it was Kevin
It's
B was
Kevin.
next.
Yeah, it's Kevin. Go ahead, Kevin. Welcome to the mic.
Hey there, thank you. So, I mean, we've seen it all from FINRA and the SEC up to date. We know their goal, their objective. They will want to throw us. They will want to disturb or interfere with whatever actions we're taking or progress that we're making. And I look at this in the light of that. So I think this is an obstruction, or they're trying to make it an obstruction. But that said, I do have a question. It may have been answered early on, and that is, so does this, and at what point and how does it open up discovery? And let all be told.
It opens up discovery through an answer formally if a complaint is filed, right? So that's how I was able to retrieve the information that I was able to get. It was through an answer from one of the defendants in the case, and it clearly showed that that matter in itself was a private entity, not DTC eligible, and it was issued. I'm sorry, it was identified by the SEC as well. But yet here we are. It's still trading. So what are you doing?
So in that case, the company responded, and that resulted in discovery.
Discovery was shown in that case. So yes, it does result in a form of discovery.
Okay, sounds good.
Thank you, Kevin. And thank you, 100, for staying up here and answering all these questions. Thank you, Kevin.
I will always be here to defend this community. Always.
That's so nice. Thank you. Pops, go ahead.
Hey everyone, I just wanted to pop in. I've been listening to the spirited conversation going back and forth. I'm grateful for 100 and Junk and Anna and for Kevin and all these individuals that are bringing forth this conversation. One thing I do want to point out is it's still speculative of what that Wells notice means. We do not, as a community, have any idea which direction this will go. So to corral this back in for me, I hear a lot of people's opinions trying to persuade or voice their concern about how it might go, but might is not a surety. It's only a speculation. And in my personal opinion, John has been exceptionally transparent in his actions since the onset. He has been nothing but helpful to the community, going on TV, the Charles Payne things, going on YouTube, talking with GTII and Roger Hamilton. Everything that John done has been very public. If this man is trying to hide something, good luck. I just do not feel in my heart that John nor George are capable of that type of acts of deception. And that Wells notice brings up deception, fraud, record transitions, and asset issues. Well, yeah, there have been those issues. If we think about that back to the Torch days, what got us trading in the first place is incorporating all of those descriptives, that there is deception, fraud, record issues, transaction issues, and asset issues if our placeholder, which was never supposed to trade, starts trading. And I believe even further that with both of the entities, John and George, hire and shared Intel and West Christian, to prove innocence and to prove that there is a shared disparity and dilution of the stock, they're only furthering efforts trying to say, look, we have a problem. We know there's a problem. We've known there's a problem since 2008 when, and as far as the general public and retail public knows, since overstock days. Patrick Byrne, I mean, we have him clearly. He was coming to our community and stated that this is a well-known issue. The difference that I see is the fact that today we have the ability to communicate in a much more faster realm. I mean, we can do emails instead of letters. We have a very public platform with Twitter, with Reddit, with Facebook, and all of those different avenues to communicate much more faster and much more direct. And plus, it gives us much more greater ability to do due diligence and research. So I look at this and go, well, here's our thing is that it's still speculation, but when we do our speculation, we get to look at that from the factual point of view. And look what Huckleberry just produced here, what was it, 3 weeks ago? He went through and answered all of the filing questions about the laws that could have been incorporated and could have been broken. And he dispels a lot of that by that. So our community just needs to sit back and take a breath, in my opinion, not trying to tell anybody what to do, but I just feel like we need to sit back and take a breath and let this thing play out for a bit, because we do not know what is guilt and what is innocence until the judge and jury meets on this thing, and then we can just voice our opinions and displeasure or our appraisals based on what the actual litigation says.
Thanks for that, Pops. Appreciate it very much. Thank you. Guys, I apologize. I don't know who's next, so we're going to go Biotech David and then Nodnarb.
I think
Biotech.
it
Welcome.
was, yeah, I
Oh,
think it was David and then Biotech and then Nobnard.
okay. David, welcome to the mic.
Hi, can you hear me?
We
Yeah,
can.
fine.
Yeah, so obviously we don't know the final answer until we see the official complaint or charge. Just want to point out one thing. I think as of today, metamaterial did not, in any filing, they say they are cooperate with SEC or they are being investigated by SEC in their filing, right? My point is, if we're looking at GameStop, when SEC contact them for information, they do put the wording in the filing. And as we know, the well notice is only issued by the end of the complaint, or end of the investigation. So my point is maybe they are just kind of witness, not the subject for investigation.
Thank you, David. Biotech, go ahead.
Yeah, that actually, that previous comment leads off well. So in the last 10Q that Meta let out, they actually did disclose that they'd received a subpoena from the SEC. And the dates that they said that they received the subpoena actually does help us understand what this Wells notice could be related to. So the subpoena that they mentioned in the last 10Q was received in September of 2021, which means the SEC was investigating them or looking into the spinoff prior to MMTLP ever trading. So that means that this was not actually related to MMTLP trading. It was related to the initiation of that spinoff. So I think that's kind of important to know. And also the Wells notice does state that this is the end of an investigation that was previously disclosed. And this Metamaterials 10Q is the only disclosed SEC subpoena from any of the companies. So we do kind of know the timeline on this, and it should impact sort of how this is all interpreted. So the idea that maybe this was the issuers from the FOIA email could be the ones who got MMTLP trading. This is all an investigation that started before MMTLP ever traded. So I think that's pretty important.
Thank you, Biotech. I appreciate you bringing that up because I do think that's really important, guys, that, that's something we also need to bring to Congress. This has nothing to do with the imbalance of shares in MMTLP. So this does not negate our efforts that we're pushing forth to Congress, which is to get the numbers from the broker-dealers. So that's a great point, Biotech. Thank you so much. Nobnar, go ahead.
Hey, can everyone hear me?
Yeah, I hear you fine.
Awesome. I have one question, or actually I have two questions. The first question is for 100. He had made a comment about shares needing to be an AST, and if they're not an AST, then they're, I don't want to use the word counterfeit, or counterfeit. I don't know if he used that word. I can't remember. But we still have the option. We still have the option
Busy.
to hold.
Nobnard is talking. Can you hear him?
Oh, no, I'm glitching. Okay.
Oh. Do we still have the option as, owners of NextBridge, when we do get our NextBridge shares, to hold them in our brokerage accounts as street name value?
I believe whatever is in your brokerage account has to abide by the corporate action that was approved by the board of directors and in accordance with Nevada state law. That's
okay.
it. I can't answer your question until there's resolution, right?
Yeah.
No one knows that answer. And the word that I used was an IOU.
An IOU, yes.
Yeah.
Because I was under the impression from the S1 that we had the decision to either transfer over to AST or to hold it in our brokerages as a street value or a street name, and then we would run everything through whatever brokerage we were holding that in, rather than AST. And then the second question that I have is, do you think that this 8K that was given to Meta, are we going to be expecting some type of news now via NextBridge, since they might be pulled into question about, maybe a share count that they do know of, or an imbalance of share count?
I think Meta will probably make a public statement about it in a PR. That's what I've experienced in the past. And it seems to be what all of these different issuers that are fighting these naked short issues, they're making public statements. So it would make sense if Meta would make a public statement. in regards to it, or even NextBridge, yet to be determined. But damn, there was something else I wanted to mention. Oh, the reason why I'm using IOU is because if you owned MMTLP and it's not supposed to be tradable, you own it electronically. So that's what makes it an IOU. And that's why I'm saying that if the certificate is held at the broker in street name, there's nothing that can identify you on that cert until your name is put on that cert and transferred over to AST and it's registered in your name. That's why I said what I said. You don't own NextBridge until your name is on that cert and it's in AST's custody.
Yeah, that makes sense.
Yeah.
One question that arose as we were talking, is Meta Materials legally obligated to file this 8K to let us know about this? Or do they have the decision to tell us through PR, and their decision was to tell us?
So it's my understanding that it is a voluntary action, but because George P. is a CEO, and this is based on what two of our legal professionals came into the environment and they said on the former space call with Gray, they said that because George P. was a CEO, it is required that the Wells notice be notified to the public.
Thank you so much.
Thank you. I think it was Sam and then Whiskier. Thank you, 100.
Hi, Anna.
Hi, Sam.
Yeah, I remember the S1 containing information about an investigation, an ongoing investigation. And if I recall correctly, one of the first S1s, I'm not sure, what revision, what amendment number, there was um, a some information that talked about how there was an ongoing investigation. And not only that, I think it said something about that NextBridge Hydrocarbons was not involved. And I think that there may have even been some indemnity or indemnification language in the S1 that was put in there. For some reason, it's been a while since I've looked at the S1, and the one that I pulled up was the original filing. That's the only one that popped up when I searched it on my computer, and I still haven't pulled up the correct one. But if I recall, there was, and I remember, I just go, look at this. I just remember my reaction to it. Here now, they're putting this information to try to, scare you off, from this play. So if somebody recalls or can pull the actual S1 filing, even the last revision or the last amendment, I should say, you'll see that there's an ongoing investigation, and it talked about an indemnity clause, and it also said something about NextBridge not being, or NextBridge nor any of the board members, if I recall correctly. And I'm I'm an old man, so I'm my brain is not what it used to be, but I'm 99.9% sure that that's the language that was on there. Can anybody elaborate, or has the S1 the amendment handy, and then they could just do a find search and look into that.
Thank you, Sam. Whiskier, go ahead.
Thanks, Anna. I just wanted to elaborate on what Biotech was saying. If memory serves me correct, it was Q3 2021 where metamaterials disclosed that they have been requested by the SEC to provide them information. So that we're talking about September 2021, and that they were complying with the SEC at that time.
Thank you, Iskir. I think it was Swing and then Mike Q and then Michael. Go ahead, Swing.
Go to Mike real quick. I'm actually
No
pulling stuff
problem.
out of the oven.
Go ahead, Mike.
I just wanted to, they got 30 days. I'm trying to think, if they got 30 days to respond. I don't know if we see the response or not, but if stuff starts going on in the next 30 days, that hopefully, if certain events happen legally, that we might get this whole thing resolved quicker. I'm just trying to think, the different ways this can get us resolution by entangling all the nefarious actors in the whole thing and exposing the whole thing and busting it wide open. I'm hoping that's the result of this. Even if they're trying to go after Meta or whatever, I'm pretty sure that Wes Christian and them are sitting on a lot of information in their file. But anyway, this hopefully it'll help speed up the process. Just trying to stay positive.
Thank you, Mike. Yeah, guys, I think it's just really important that we realize that these are two separate issues. What is kind of been put forth today is an investigation into something that happened prior to, what has occurred with us with MMTLP. So we do not need to let up our pressure on Congress. We know that they are hearing us. We have so many different people within the community that are working with their representatives and that they are wanting to help us. And all we're asking for is transparency from FINRA, from the SEC, and from our broker dealers. All we need is a share count. If it's not been oversold, then why is FINRA being so difficult and pushing back with Congress so much and not wanting to release these blue sheets? And they're putting forth lies to Congress, right? So that's why it's important that now we're asking Congress to subpoena the 105 brokers. Just show us what the share count is. How many shares did you own? Did you sell them in? How many are short and how many are long in MMTLP? And that's what we need to get to Congress. So let's continue to push that, guys. This is not a time for us to let up. In fact, I think this is a time for us to continue to push forward even stronger. If you made 3 calls today to Congress, make 10 tomorrow. This is just a time to keep pushing, guys. So let's not take our foot off the gas. Thanks. Go ahead, Swing, and then Savvy. Or go ahead, 100. I think you were going to chime in on that.
I was just going to say I found the language, the subpoena language on the S1. But go ahead, Savvy or Swing.
No, if you want to chime in on what was said earlier, continue the conversation.
Yeah, I also found it.
Okay, good.
Ladies first, go ahead, Savvy.
Yeah, go ahead.
Oh no, there's multiple hands up, you guys. I can wait in line. It's not a problem.
All these
Michael's got
gentlemen in
his,
this space.
James got his, Sam's got his. No, you guys go ahead. We'll go in order.
I got. Can I speak one more time? Hello?
Someone speak.
It's
Go ahead.
Michael. Go ahead, Michael.
Okay. I agree with most everything that's been said by Dragon, mainly GP and Brda into this, for which I believe they're 100% innocent, but nevertheless, by dragging them in, I do believe it's gonna, now that they've trying to put the spotlight on them, I think it's going to help facilitate, as people say, discovery, more of the truth, the real truth, everything I hope is going to come out and it will be addressed appropriately. And, it'll have a nice ending for everyone. My thing is, sometimes innocent people, sometimes, I mean, in an investigation, it's not like they're sacrificed. It's just like now they're going to have to defend themselves. And now they're going to come out swinging, as they should. And so, I think that's going to bring some things to light and put spotlight, maybe direct it. They're going to try to direct it off of them. Of course, they're innocent, and put it where it belongs. But now the big boys, they're gonna have to fight. So that I'm not necessarily happy about that for them, but at the same time, there's a lot of people got hurt that mainly. And the other thing is, I don't understand if this would have been appropriate or even if they could. John Brda supposedly, and I have no reason to doubt it, although I didn't hear the phone call, and it's not my business to hear the phone call. But he called whomever, the OTC or FINRA, whoever, and said, "Hey, this is not supposed to be trading." And they told him basically to go F himself, and it's tough. She's on. Well, in my line of work, I advise people about maybe what kind of safe they need for whatever. Maybe some people need a burglar safe, but they don't need a fireproof safe. Some people need both, whatever. So if I knew good and well you were about to stick a lot of paper money into a burglar safe that had absolutely no fireproof, I saw you about to make a huge mistake. Would I not do what I could if I could get to your face, which John Brda could not, or George, or all the big guns? They couldn't, but they have a website and they have a ticker that they could have somehow got the word out that, hey guys, look, this should not be trading. If you put your everything in it like you would put in a safe and it's not fireproof, and we telling you that this safe is not fireproof, this trade it should not be trading. And we're trying to warn you. I mean, that was since it started trading from the very beginning. Couldn't they have put some on? They couldn't. Maybe they couldn't put it on their ticker, but they have a website, and that's a personal website. How many people? I mean, it might have saved. It wouldn't have saved everybody from dumping their 401ks and a lot of money in, or just other people put money in. But I don't know if it's wrong. It's looking back. It's 2020 hindsight. It's beautiful. I understand. But if Brda knew that, and he knew way back, as most people didn't know. Well, I didn't buy any, like I said, but I know people that did. But those people didn't know what he knew. Why wasn't he screaming from the damn high heavens with whatever platform he had? He couldn't pick up a phone and call everybody. I understand that. He couldn't take out an ad and every
Hey,
damn
Michael, Brda's not here to defend himself, so I'm going to change the subject if that's okay with you.
That's fine with me. I'm just saying somebody could have put it out that, hey, this
Well,
is.
we don't know that he could have, because we don't know the situation surrounding it, if attorneys advised him not to. So I think unless he was here to defend himself on that, I'd rather not dive into that right now.
I understand, but I'm just saying that's it. Thank you.
Thank you, Michael. Okay, I think Swing was next. Swing, are you back?
I am. I'm sorry.
That's okay.
I kind of wanted to point out I call it the elephant in the room, if you will. So this 8K came out, and forgive me, the gentleman that came up earlier was asking, was it a requirement for the 8K to be filed? Actually, it's not voluntary, nor is it required. That 8K is any public company has to file anything that is required by the SEC. So when the SEC came forward and said, hey, we've got an active investigation, and we have this Wells notice. The Wells notice comes at the end of the investigation. So there's obviously been an investigation for quite some time. George Palikaris, months ago, posted a picture of himself looking very perturbed outside of the FINRA office. I've always had his back when it came to what was going on with the filing, how MMAT-A became MMTLP. I personally believe that this is a sign of not only the work from the community, but also the people behind the scenes that are doing all the work that we don't know about. And a lot of people are complaining that they've been really silent. They haven't said anything, and we need to hear something. I think this is all part of the plan. And eventually we're going to get some information that is going to say one way or the other, good, bad, or indifferent. And I'm not saying it's good. I'm not saying it's bad. I'm not saying it's indifferent. But we are going to get a resolution soon. Like I've always said this, I don't think we'll ever trade again. However, if Congress implores FINRA or the OTC or the DTCC to come up with a resolution and it goes to arbitration in some way, shape, or form through a subpoena, it may get resolved that way. I'd love to see it trade again. I'd love to see an HKD type move. However, we got to be realistic, and I want you to keep your expectations like right in even keel, if you will. But Anna, you are 110% correct. This is not a time to let up. This is time to persevere and keep going and keep pushing. I got aggravated a couple weeks ago. I was talking to Busy. I was like, you know what? I don't care if this shit ever resolved. I'm over it. And it wasn't because of the MMTLP situation. It was because of all of the infighting. And I'm over that part. And I think everybody needs to focus their attention on what just happened. In my personal belief, this Wells notice, it only comes at the end of an investigation. Everything I've looked at, end of an investigation. Do I think George was complicit? No, I don't. Do I think Brda was complicit or guilty? No, I don't. These buttholes decided that they were going to try to go ahead and screw everybody, and they did. And I think they're actually in that room with no corners and nowhere to run. And I think we're at the end. Or if not at the end, we're getting really damn close. So don't let up.
Thank you, Swing. I think it was okay. I'm pretty sure it was Hollywood, and then maybe
Actually, it was me, if you don't mind.
Oh,
Sorry, my hand came
John.
down because I spoke. Guys, I just wanted to make a couple points. I know I made one of them earlier, but I just want to reiterate it again. But this is a point I wanted to make is whatever potential alleged, we don't know yet until there's a filing, as 100 is spoken about, whatever possible wrongdoing may have taken place surrounding the merger and spinoff in 2021. It does not negate all of the wrongdoing, all of the crimes, all of the infractions, the breaking of rules and protocol that has happened since then. It does not negate the actions of the market makers who created the naked shorts, the counterfeit shares, the brokers who sold them to us, and FINRA for covering up for it. I think it's very possible that this could be a deflection. Not that I'm saying that there's not issues there. There very possibly could be. And if there are, they should be investigated, and we should be made aware of it. But whatever actions George or John may have taken does not negate or justify any of the actions that have been taken since then. The SEC, FINRA, and OTC markets knew the day after this started trading that something was wrong. John Brda talked to them, GP talked to them, there's a whistleblower that talked to them, and they did nothing about it. Nothing. So they've got exposure here too, and whatever charges they potentially could file if that's indeed where this is going, we don't know yet, does not change the facts that we have FOIAs that show that they knew and they continued to allow this to trade. They could have stopped it at any time. As regulators, they could have stopped it at any time, and they didn't. In fact, they doubled down on it. When they had the blue sheets on the 5th, they issued a corporate action on the 6th, which told me personally I could safely buy the security. And then they doubled down on the 8th and told me again that I could trade. The brokers read it that way. Mendel on Vice President of OTC Markets read it that way. Whatever's going on with this Wells situation doesn't negate their exposure. And that's what we need to focus on. We still need, and I agree with Anna and Swing and everyone that has said, this is where we step on the gas. This is where we stay focused on the fact that we were either sold counterfeit shares or we were not. Sorry, guys, I'm losing my voice. We were either sold counterfeit shares or we were not. And a legit audited aggregated share count will prove that. So I just wanted to say that.
Thank you, Sabby. Yeah, this is all really important conversation, guys, because exactly what Sabby said. I 100% agree. Thank you. Okay, I think it was Hollywood, and then do you guys know what order the hands were? I think it was Hollywood, Smokey, Curtis, 100, or 100, and then Curtis. I'm going to go in that order.
I think we're leaving out Sam. Sam has had their hand up for quite a while.
You know what? I'm scrolled up and says Sam is cut off at the bottom of my thing. Okay, Sam, go ahead, and then Hollywood. Sorry, Sam.
No, it's okay. So, Anna, I sent you, and you could put it up on the Nest, on the S1, and I'll just read it. It's a small paragraph, and I'm going to put it all in context to tell you guys that this is an absolute nothing burger, in my opinion, not legal advice, not whatever, but I'll put it all in context for you. It's so, like I said, in the original S1, this paragraph was not included. It says in September 2021, Meta received a subpoena from the SEC Division of Enforcement in a matter captioned in the matter of Torchlight Energy Resources Incorporated. The subpoena requests that Meta produce certain documents and information related to, among other things, the merger involving Torchlight and Metamaterial Incorporated. Meta is cooperating and intends to continue to cooperate with the SEC's investigation. While neither we nor any of the individuals who will serve as directors and officers following the spinoff have been named or otherwise involved in the SEC enforcement action, in the event we incur any loss with respect to such action, we will be entitled to seek recovery from Meta pursuant to the indemnification provision set forth under the distribution agreement. Now let's go to the Wells notice. Let me just pull it up real quick. And if you look at like the second paragraph in the Wells, I think it's the second paragraph, but let me just pull it up real quick. Okay, it's right here. Sorry, I'm not so. And I'm sorry, I'm looking from my phone, so it's going to be a little bit. Out of sync. But here it goes. A Wells notice is neither a formal charge of wrongdoing nor a final determination that the recipient has violated any law. You know, right there, I feel like just stopping and just talking about this. We're jumping to conclusion. We're making this more than a nothing burger. I just think that what is suspect, in my opinion, is that this comes out, and it comes out because they know that it's going to have some kind of detrimental effect on us, whether it's psychological, whether it's that the fact that we have to defend ourselves or defend a company of something where there hasn't been any formal charges. It even says there that a Wells notice is neither a formal charge of wrongdoing nor a final determination that the recipient has violated any law. It allows the recipient the opportunity to address the issues raised by the enforcement staff before a decision is made by the SEC on whether to authorize any enforcement action. My God, where are we going with this? Why are we giving it the attention, in my opinion, that this does not deserve?
Well, because it illustrates 10B, right? And if 10B is referenced in a prior litigation, meaning McMillan versus Meta, then you have to consider what the contents of what was in that complaint. And that's why, I'm very interested, because we have, 3, 4, maybe even like 100 people on this call that are long-term shareholders that are more familiar with the details of that case. So I'm curious to see what they say about it. So that's why this is important.
Well, it's important, but okay, it may very well be important, but the fact that we're already giving it this kind of, without every 2 seconds posting this up, and that it's not a determination. There's no, yes, we gotta focus on the fact that this comes after an investigation, and yes, there's no determination. That's what we should be highlighting. Okay, we're assuming that there is something there that needs to be addressed in other than maybe something that is minor, or maybe something that was where they should have, whatever, I don't know, dotted an I, crossed a T. I do not trust those that would issue a Wells notice at this time, and that Meta would have to respond to this. I just look at it as a nothing burger, and to make it bigger than it is at this point without really addressing it. Now, is this more of a meta issue, and this should be discussed under a meta materials issue? Yes, but as far as the next bridge hydrocarbon issue, it is a non-issue, and that needs to be stated clearly, emphatically. And the fact that we're giving it a voice at this point only gives the shills and those that want to see our destruction just a little bit more food or ammunition to do so. That's I'm done. I'm not going to say another word on this issue.
I think you're absolutely right. There's nothing wrong in what you said.
Thank you, Sam. Thank you, 100. I 100% agree with you, Sam. Thank you so much. And then I think it was Hollywood. Go ahead, Hollywood.
Hey there. So
Hi.
I think, you're minimizing it. It's not a nothing burger. They don't issue these every day. And the investigation was going on long before the next bridge halt. Timing is a little suspicious. Do they want to hurt our cause? Absolutely. But to gloss over it and think it's not going to affect us is kind of short-sighted, because
I think he was going to next bridge. I think that's what he was trying to say.
What was that?
I think in terms of next bridge, that's what he was trying to say. It's a nothing burger.
But it isn't when dealing with Congress now, with dealing with anybody, because it's tainted, whether you like it or not, whether it's relevant or not. You're going to get less cooperation because people don't want to get involved in something like this if they think they're wrong. And now it has fraud written all over it. And
well, it's not tainted because of the Wells notice. It was tainted because of prior litigation, and that's why you had all the FUD. right? That's why you had all that activity. That's why you still have these people coming into our community trying to divide everybody up. So it's not because of the Wells notice. That's already existed.
I'd like to be able to finish a sentence. Thank you. This formalizes it. An investigation is only an investigation. But now clearly they've found something. And it doesn't mean that we're not oversold, but it does mean that you can expect a little bit less cooperation. You can't pretend it's not here.
So you've already come to a legal conclusion. And if you read,
I haven't come to a legal conclusion.
No, you said that there's an issue.
They don't have an investigation, determine no one's done anything wrong, and issue a Wells notice looking for more information.
Did you listen to the paragraph that I read in the Wells notice?
I did.
So what part of that does it say that these people did something wrong that require that there's going to be some enforcement action against them?
They're not there yet, but it could go to that.
Okay, coulda, woulda, shoulda. Again,
the point is, when you have an investigation and they say there's no problem here, you're given a clean bill of health, and they haven't been. So you're going to get some pushback because it's been a hard sell for a number of Congress. And, you know, they wanted to help us. They wanted to believe that everything was from the Enforcement Act, you know, from FINRA and OTC and the shorts. And now they've been given an out that it's the company's fault, and you're just going to get a little pushback. I'm not saying that we're not oversold. I'm just saying it's not going to be as clean of a path.
I think, Hollywood, I'm just going to kind of chime in on this. I think that it's a time to ramp up our efforts. You're probably right. The timing of this, I don't think we can trust the SEC. You know, so it could be to try to paint us in a bad light. And this is, and that's a good way to look at it, because we cannot put anything past the SEC, FINRA, the broker dealers. They're all in on this to try to, you know, to prevent Congress from pushing forward to get the numbers. And so that's why what 100 was speaking about earlier about the prior case where it takes precedence, we have to inform Congress of this. Like if we because we understand what the SEC is doing, you know, the fact that they're not looking into the share count and it's been almost 8 months and they've given us nothing. I think that this is, you're right. It could hinder our progress with Congress. And so that's something we have to prevent from happening and to continue to push forth with our voices and our letters and our campaign. So thank you, Hollywood. I appreciate that.
I mean, I also think that there's going to be less George can do for us.
Well, I think George has hired an attorney, or Meta Materials has, and we do have some other speakers. So I'm going to get to the hands. Smokey, go ahead.
Yeah, thanks for having me up here, Anna.
Thanks for coming.
No problem. So I just wanted to address this. Hollywood, you're right, it's not a nothing burger, but at the present moment in time, it's not a big issue as of yet. This is definitely, I'm going to state this is my opinion, even though I don't think it is. This is definitely coming out of the 2021-2020 issue from the merger. I don't think it has anything to do with the fraud that's happened post. And I think that was said earlier too. I don't know. I joined this conversation after doing a video. This Wells notice allows for the company to go ahead and do a rebuttal. It allows them to go ahead and put together explanation, argument on why the SEC is incorrect in this. It does not mean that they're going to listen to it. Now, the other thing you got to remember is if Meta Materials isn't very careful on how they word things, if John Brda is not careful on how he words things, if it's not written just right, and they find a loophole in all of this, they can also use these statements that they're getting ready to put out in rebuttal to the Wells notice. They can use it against them. I now, as far as this 10B, that has to do with devices used to defraud something. If you guys remember correctly, and I know a lot of you are not even metamaterials investors, so you probably don't know this, but there was a lot of speculation back in the day that the merger of metamaterials and Torchlight was actually used to be a torch the sword situation. And that is very possibly what they're talking about, the whole using it as a device to defraud. So that's where the investigation popped up. They thought this was a big short squeeze being set up by both companies to basically get rid of an issue or to bring light to an issue or things like that. So this has been an ongoing investigation for just about 2 years. That's why I think it is important, but it's not as important to what you guys are doing and what the entire MMTLP community has been doing. On contacting Congress, reaching out to your senators, your state representatives, things like that. That, like Anna has said, that has to keep going. This has nothing to do with that, and that's my personal opinion. But I think it's also going to come to light to be a fact in the future. But because this is put out, I do want to say that there's a possibility that because West Christian stepped in, Flamethrower and Metamaterials, this could have pushed this into this situation and can shed light on the original problem. So I've always stated all the way back in the beginning when this all first happened, if you really want to see the resolution, if you really want to figure out what happened, you want the settlement, you want everything to go right, you need to prove the illegal act in the beginning. That initial act, if it can be proven illegal, and I think this right here, if Metamaterials, John Brda, and George Palikaris can get this ball rolling right with West Christian, this may be that ball that rolls all the way through. The first act's illegal, everything after that is illegal as well, if that makes any sense.
Hey, Smokey, can I ask you a question, man?
Sure.
Since you're the long, and Curtis and Marduk were longs here as well, in regards to the McMillan versus Meta case, it identifies that there was suspicions arising from a short seller report and statements related to the business combination of Torchlight. What's your opinion? What did you learn from that case? I'm just curious from the longs.
I don't know how much I learned from that case because I didn't pay a whole lot of attention to it, and that's just dead honest. I didn't read the case filings. From what I understand, if I'm correct, and please correct me if I'm wrong, it was dismissed on that one. There's been a couple of them.
Yeah, I know there's a couple, and I'm gonna read up on them. I was just curious from your perspective, because I always like to get the investor's perspective first before I dig in.
So here's one thing I don't pay too much attention to as an investor in a company. I don't pay attention to petty lawsuits and complaints against the company. I can't, because when you've got as many investors as you do, it's kind of like reading reviews online for a product. The only people who put a review on are the people who have a problem. All the rest of the people are perfectly happy with their product, and they'll never tell you otherwise. So that's kind of why I don't pay too much attention to those things, and I probably should. It's my own fault, though.
Curtis, Marduk.
Curtis.
Hey, good evening.
Hi, Curtis.
I love joining when there's always something going on, so that's always fun. But so to answer your question, 100, there's non specific accusations, and Whiskier was correct, right? So the SEC initial investigation that came out on the Q3 earnings in 2021, which was in November. And it references, and Sam actually already read it verbatim from the S1 as well, which really includes much of the same exact context. So the September 2021 in reference to the merger between Torchlight Energy Resources and Metamaterial Inc. But, basically, there's going to be a little bit of speculation here. I can reference the specific context that is referenced from within this Wells notice as well, within the 8K. But it's safe to assume, or at least it is my assumption, that what is being alleged for securities violations is that there was the potential facilitation of a short squeeze. That's what has been alleged in the class actions. When they reference specifically the language around 17A, 10B, 13A, 13B, 2A, 13B, 2B, when you look through and you all the way down to the very last accusation is with regulation fair disclosure. There was leading up to the merger, there were specific tweets in reference to torch the shorts. There was, and I don't even like referencing this because it was not recorded with all parties' knowledge, but there was a recording from an Italian investor group of an interview with George Palikaris talking about the uncertainties around the merger with Torchlight. And everybody remembers back to 2020 and what happened with a worldwide shutdown to oil and gas prices. It went negative, right? Everybody's well familiar with that. And so it was unpredictable as to what the asset sale could potentially be. The economy was starting to get rolling again. Everything was starting to open up. And so it was a complete guesstimate as to what those assets could ultimately sell for. And in that recording, that is the reference that many people have seen that referenced it could be anywhere between $1 and $20. It wasn't a prediction. It wasn't anything that was provided as guidance. It wasn't even supposed to be recorded. But all of that context was used against and really as part of an allegation to say, oh, look, you're trying to elicit a short squeeze, and completely ignoring the fact that, and also I should call attention to within that interview, George, and this is well known, but George calls attention to Torchlight being one of the heaviest shorted stocks on the NASDAQ. Again, because of the situation with depreciating oil and gas prices at the time through the pandemic. So, which of course is the entire reasoning behind why Torchlight was looking for an RTO partner to have a reverse takeover and to have a company like what ended up being MetaMaterials Inc. Uplist to the NASDAQ as a takeover candidate, was because they were eventually facing delisting if they didn't have a partner. So anyway, when you look through the specific rules that are referenced, it's like 10B 5 prohibits any act or omission resulting in fraud or deceit in connection with the purchase of sales or securities. 14A-9 requires that information provided in proxy statements must not be false or misleading and must include all material facts necessary to make statements not misleading. The 13B2A, 13B2B, and 14A, that's all about accounting. So it pertains to the maintenance of accurate books and records by the issuers of securities, internal accounting controls that must be maintained by issuers of securities, solicitation of proxies from shareholders, and establishes regulations by proxy solicitation. So all of this is a catch-all, right? I think my assumption is the overarching argument is going to be that alleged John and George were trying to facilitate a short squeeze. The irony in all of this, that every single investor, whether you were an OG shareholder in Torchlight Energy Resources, whether you were a MetaMaterials Resources investor, whether you bought into MMTLP and you were familiar with the matter that took place prior to that point, what was very obvious was there were share imbalances, there were preferred shares that suddenly became tradable in October of 2021. It ignores all of those prior facts. So it's very ironic that this came out, and it was no coincidence when this came out in November of 2021. And if you look at the stock chart for MMAT of what happened once that earnings was released and this SEC investigation was announced, they really went in heavy against the against MMAT, shorting the hell out of it, and up until that point, it was at pre-merger highs just prior to Labor Day of 2021. So it's obviously a very coordinated effort. I don't think there's any kind of coincidence within the timing. I think there's validity in both what Hollywood and Sam said. It's not a nothing burger, so I don't want to dismiss it. It is also not a formal determination of anything. And if anyone remembers back, I mean, John has addressed this semi-publicly, discussing some of the questions regarding the merger and the SEC investigation. Former CFO Ken Rice actually spoke to it a few quarters ago while he was still employed by Metamaterials Inc., and suggested that this would be finalized with their expectation at some point in the first half of 2023. And obviously now we're into third quarter, but this is all to be expected. They're going to come out with some level of accusations and findings in this. It's not indefensible. So, and really knowing what was publicly available and what has been accused, and 100, what you're calling attention to, right? So what has been alleged within previous class action, I think is all very easily defensible. And it does, interestingly enough, open up this and I don't know if this is happenstance or not, but it opens up this microscopic view of exactly what happened prior to the merger, what happened at the point of merger, and then hopefully a continuation of that conversation thereafter. But I want to reiterate what Anna said as well, and part of what Sam's point was. This is going to be used. You should just expect, worst case scenario, that this will be used as an objection, as some kind of obstacle in conversations where people will point back to, oh, well, there are now formal allegations that the company was participating in some level of securities fraud, right? And it's generalistic because we don't have a formal filing now. All we have are the specific sections of the Securities Act that are referenced, which is basically a catch-all when you read through each one of those. So it's really important to overcome those objections because, one, this is something that has been open since September 2021 and that the public has been aware of since that quarterly earnings filed in November of 2021. And it also just completely ignores the fact, and Junk said this more eloquently, completely ignores the fact that, oh, by the way, we know because of the FOIA response that not only was the SEC and FINRA aware of not only potential fraudulent activity that was occurring around the tickers, but the potential share imbalance and the uncertainty in the clearance processes and settlement process that was supposed to happen as part of the formal spin out in December of 2022. So anyway, this is not to be surprised. It looks like it's an obstacle stuck. Very convenient timing for the SEC and FINRA to try to stall momentum, but it's nothing that I don't think we can overcome any kind of objections to.
So it gives me the impression that this is an act of interference with the company's progression because it was trying to address that it has a short position attached to it. And it's just a pattern of behavior that repeats itself in the past, and it continues to do it today. So that's why I wanted to ask, long shareholders of their impression, because there's no better witness to these events before you actually read the litigation, because the litigation is cut and dry, but it doesn't tell you what's going on between the scenes. So thank you. I appreciate you answering.
Sorry, guys. I think the next person was Marduk and then Qtainment.
Just really quick, though, and a little housekeeping. If you've already shared your comment, if you go ahead and drop down, we've got people requesting mics and we're out of mics. So if not, if you don't raise your hand, I'll go ahead and drop you down for you.
I'll drop down.
No. You need to stay.
Drop or get dropped. Hello. I
Marduk,
missed
welcome.
quite a bit.
Sorry,
I
my
missed
daughter
quite a bit
walked in.
today.
Go ahead. Hi, Marduk.
I just said I missed quite a bit today. I kind of just got here not too long ago. Did you guys discuss the similarity to Overstock in this situation?
I think 100 mentioned it on the last space, or somebody did, but
Yeah, we talked about it a little bit, but feel free to expand, maybe for those that are new to this space. Marta, go ahead.
Okay, so I don't know. I saw this screenshot. Somebody posted it. I actually can't find the person that originally tweeted it because somebody left a comment saying that Patrick said this was going to happen or something like this would happen. But I find it incredibly ironic that within a couple weeks of Meta releasing a PR going after naked shorts openly, the SEC all of a sudden decides to jump into action. A little odd. Seems a little odd.
It's a good point.
So I don't know. Just it is what it is. I'm not worried either way. Like I'm reading it, and although it's not, I wouldn't say it's a nothing burger. It's definitely a something burger, but it doesn't necessarily mean that it's a Brda and Palikaris are in trouble burger. You know what I mean? We're just gonna have to see what happens, but either way, I think it's pretty ironic and kind of funny that and now I can only expect that this is going to be something that they'll use to kind of stonewall us or whatever, but I don't know. Like I said, I missed a lot of the conversation about this and what happened today, so if, yeah, I'll just leave it at that, I guess.
Yeah, one quick thing, Marduk, because I want to make sure that we address this too. So this was laid out back in November of 2021. I realize a lot of people weren't familiar with this situation at this point in time, but Seeking Alpha is full of garbage. There are some meaningful articles on there. Just depends on who the author is that's actually publishing content. It's kind of a pay to play platform, but there's an article and it's dated. It's almost 10 years old. It's from 2014. And anyone that hasn't read it, if you just Google anatomy of a short attack, you can look through, and it goes through specific tactics that are still almost 10 years later to a T followed today, to a T. And you can look at it. Again, this is a nearly 10-year-old article, and the typical tactics include flooding the offer side of the board, spoofing. We've all seen that. The next is a media assault. We certainly haven't seen that in the last 3-4 months, right? From our friends at Forbes or Wall Street Journal, James Angel quotes. We certainly haven't seen anything with a media assault, right? And then analyst reports. We've seen our fair share of those. Planting moles in target companies, frivolous SEC investigations, class action lawsuits. It's like a checklist that we're going through here. Interfering with target companies' customers, financing, pulling margin from long customers, paid bashers, the works. It's literally a blueprint that has been followed to a T. So back in 2021, we were waiting for this to come to fruition. There is a silver lining in this, in my opinion. As what's been stated time and time again, the Wells notice is provided at the tail end of investigation. So at that point, they have formal allegations to whatever parties, and then they have the parties have 30 days to prepare a response to address the allegations with any kind of counter evidence and support to counteract that. One of the responses that has been in common for the FOIA responses and just for non-participants from both the congressional front, from even when we're reaching out into these various regulatory bodies, has been this open investigation, which is open-ended because there is no end date. There's no SLA for an end date for this investigation. It was just a giant unknown. And there is a silver lining that I fully expect. My expectation is that they will defend against this. They've been providing and cooperating with the SEC in this investigation since September 2021. That's been publicly disclosed to this point already, and it's in each one of the quarterly findings or filings. So we already knew that. But the interesting piece is if this is resolved, whether favorably or unfavorably for both John and George, the interesting piece is that excuse kind of goes by the wayside. So using that as a cop-out for rejecting FOIA responses, for rejecting involvement for an open SEC investigation that no longer is applicable, that excuse is expired. So knowing that we are in a narrowing window for that excuse to expire is definitely a silver lining for me as well.
Well said. Thank you, Curtis.
Thank you, Curtis. I think it was Qtainment next. Go ahead, Qtainment. Welcome to the mic.
Hey, what's up, Anna? Busy, Junk Savvy. Good to see you all again. I wanted to chime in on what Sam had said earlier. He is absolutely right. This is not a indictment or anything like that. It's not a allegement of, oh, hey, we're pressing charges against you for fraud. No. However, this is not a nothing burger. This I think is somewhat of a good thing, though I think that the SEC is a little bit slow at the push. Now, a Wells notice in particular is the SEC's way of saying, hey, we're investigating and we have questions for you. It's essentially an FYI. We are establishing an investigation and we have questions. Now, take a look at that first section. They reference section, what was it, 17A? 17A makes it unlawful to employ any device, scheme, or artifice to defraud, obtain money, or property. Now, doesn't that look familiar? Haven't we seen that before? Interesting. Didn't we discover that information 7 months ago when we found out that Ari Rubenstein was previously investigated for the same thing, the Curta law firm, to implement any device or scheme or artifice to defraud? We have seen that before. So essentially what you have is the SEC, they're on the ball, but they're miles behind. I think that their investigation is a little bit slow. I think that their investigation should be more so geared towards FINRA and the brokers primarily. But this Wells notice isn't a bad thing. It essentially says, hey, we see what's happening. We're doing something about it right now. It is essentially a public notice of that. And if anyone is wondering how I know that, I have family that works for the SEC. So, that's all I'm going to say about that. But I think that this Wells notice is somewhat of a good thing. But it is showing that maybe, just maybe, the SEC is a little bit behind on all of the information. So if you're listening to this space call right now, you all are behind. You are behind. We had this information several months ago. It's time to get on the ball and check the information that we all have shared collectively over the past 6 months. So that's all I wanted to say about that. Thank you for the mic, Anna. Thank you, Busy, and thank you as well, Junk Savvy.
Thank you, Entertainment. Does anyone want to chime in on that? Okay, then I'm going to go to Hans. Smokey, I think you were next.
Cool, thank you. Just really quick, I want to do a shameful plug. Yeah, I said shameful. It's funny. Anyway, I put two things up in the nest. First thing I put up in the nest was the video from tonight, just explaining my opinion on the Wells notice, and I agree with Curtis 100%. Of course, I do. And I also put up there in the nest the anatomy of a short attack. It was a tweet I posted on April 21st of 2022. It's that old. Anyway, and my last shameful plug I'm going to put in there is I am most literally a time capsule for metamaterials stock. No freaking joke. If you want to know any of the information that Curtis is talking about and you want to see it in bite-sized bits, and when I say bite-sized, I mean you're going to really need some serious time because I make long videos. But I go through a lot of this information through all of the queues. I've read most of the filings on live or on video and break those little intricacies down and talk about how we've had this investigation ongoing. I've got Ken physically saying how Metamaterials expects for this investigation to last X amount of time. We've recorded all of those different calls that they've done. So my channel is a space-time capsule for metamaterials over the course of the last 2 years. So if you guys want to get up to date, I put decent descriptions. You don't have to watch videos if you don't want to. I don't care. But it's just a good opportunity for you to see little bite-sized pieces if you want to. The description will tell you kind of what it was all about. I would focus on filings, and that would be about it. Everything else is kind of just me throwing my arms around, getting all excited for Meta and what they're doing. But the filing stuff's very informative. There's always a lot of cool information. Anything that says that they're doing a call on Squire, things like that. Awesome stuff. That's my shameful plug. Sorry.
No, thank you, Smokey. You've always been a wealth of information, so thank you. Swing, or I'm not sure if it was too big D or I think Swing was next. Go ahead, Swing.
Nah, I don't even remember what the hell I was going to say. Go ahead.
Okay, go ahead. Number two, big.
Yeah. Big Daddy Pencil. Hey, everybody.
Oh, sorry. But I didn't click on you, and I only see number two, big D. Sorry.
Two Big Daddy. Number two, Big Daddy Pencil. I changed it. Somebody said that, so I had to use it.
Sure.
Oh my goodness! I'm gonna stay away from it now. All right.
Yeah.
Mrs. Pencil's laughing in the background. Hey, thanks, Busy. Curtis, going back to that FOIA stuff you talked about right at the very end. I touched on this, and I know you guys have been, reading people's denied FOIAs based on the exemption 7A. You know that they say that they are utilizing that, but they did make a proactive statement in there that when it is no longer available to them, that everything's being denied under 7A. But when it's which is the investigation part of this, whether they're not acknowledging whether there is or isn't, but when that provision is no longer applicable, they're saying that they're just going to go on to the next, whatever else they can do to delay the FOIA or deny FOIA requests. So you're utilizing them in order 1, 2, 3, 4, 5, 6. They're just going to keep denying under different exemptions. So do you have any comment on that, Curtis?
Yeah, they'll use any scapegoat that they can to not provide a response. That's status quo. I'm honestly surprised that that we got back a response that we did, and that the information that was included in Visible was not redacted, including the SEC domains that were included to allow us to know that they were well informed as to the situation. So, but yeah, my expectation. I mean, we may get a fresh laundry list of denials with new reasoning, but this has been the most common. Just I don't know. It's a half-ass excuse to
Well,
me
it's the
that there's an open
yeah, they
investigation.
utilize the default even if there wasn't an investigation. So basic, it's ridiculous to say we're not admitting that there is one, but you're not going to deny under an exemption that doesn't exist if you don't have one. So it's just, they excuse me, ice cream. Um, so we knew this investigation from the very beginnings. From early on. Again, I guess my question would be if you if you if they had, well, they did have, since they had this investigation going, why in the world would they have allowed this to go trading?
Exactly.
The
Like,
first thought, that's my first thought. I go, so you're looking at fraud, and yet you let this trade. And then on the FOIA that was released, they talk about the fraud radar even after it started trading. So you have this.
correct.
This is illogical, completely illogical. It's like making up stories as they go along the way. You would never have allowed this to trade, and then it goes on the fraud radar after it starts trading. But you already have an investigation into what you think might be fraud, and then you come around to 2022, and they're pulling blue sheets, and it's on their fraud radar. Oh, come on.
Yeah,
Right.
it's just too much. It's too much liability.
Yes.
It's just it's everywhere.
Yeah, and it's like it's not hit. It's out there. It's there. Okay, it's not even deniable, right? They've said it. The stuff is in writing. It's so I just from the get go, right before October 7th, when this thing came on the market, started trading. Prior to that, they're already telling you that there's this, and then I do recall a picture of George in New York. Was it the FINRA? So obviously we know he's been there. We didn't know why or what necessarily for sure, but this has all been ongoing. There's no surprise about this. I think you have to take this, like everybody's saying, and put into the context that it is. This is what was already known. This is just, and you do know the investigation's over based on the fact that the Wells notice is out. It says it in the Wells notice. They're giving the investigation's over. They're giving them 30 days. It's not, is it started or are they starting it? It's over.
Correct.
We do know
That's
this.
correct.
I'm just letting people know. We know the investigation's over. Most of these things take like 2 years. We're near the 2 year mark from the time we may be at the 2 year mark right here in August, right? So they may have latched right onto it. So it's not a question at all as to whether this investigation is over. It is, and they are giving them time to respond. So, and I would question as well what, let me go, I'm kind of lost my train of thought there. The investigation, I have to come back in 1 second. Somebody take the mic. There's something.
Well, the one
Oh,
unknown is you're correct, right? So they don't supply the Wells notice until the conclusion of the investigation. But what I don't know, if there's even a precedent that's set. I'm sure it varies depending on what the level of rebuttal and the amount of supporting evidence, the counter evidence to declare some level of innocence or denial. Like what is the SLA behind that, right? Like what is that window of time before we would see another
yeah.
response, before this would conclude? Because my assumption is they're absolutely going to provide, and likely already have provided, much of that
I agree.
context.
Hmm.
But yeah, but that's the
But
question, is
it's a
what is
legal
that?
filing now. They got to rebut. Sure, they know what their rebuttals are because
Yep.
they've been answering. They've been meeting, right? So the other one had to do with like Sam and Hollywood. I think was talking, if I'm right. I wasn't looking at my phone, but I recognized voices. So is right when you said that, and that went out of my head. Oh, with the regards to senators, with Congress, etc. This whole thing about the little bit, this I believe like a Jeff Sessions, excuse me, Jeff Sessions would know through conversations that this was at with that possibly. I think there's a possibility that they're already had conversations and they know. I don't think this is going to be I don't know that this is going to be. I don't know that this is going to be a surprise necessarily. They may not act like they are in the know, but there may be a possibility that they are in the know because they've approached them, and maybe the SEC has informed them of what's going on and the Wells notice and blah blah blah. I don't know, but it's a possibility that they already are in the know. Any thoughts?
So it's kind of hard to look at from the financial implications behind this, but when you look at operational expenses on metamaterials, because this is the only public record that we have to go off of what has been done other than just public testimony, right? That John has shared regarding, and John has shared very specific feedback about this, and in no certain terms, he basically said it's BS. But there was significant legal expense, but it's kind of baked into the rest of general and administrative expenses. But when you look back through the filings, I'm going to probably misquote the exact amount, but there was an increase. I'd have to go back. It might be from Q1 or Q4, but there was an increase in $2.4 million in professional fees that were due to increase in legal costs associated with the SEC investigation and lawsuit.
I can concur with that.
Yeah, so that expense didn't come from thin air, right? So that came from prepared statements and any kind of formal response that came from their attorneys within metamaterial. So you could, I think it's probably safe to assume that there is already these allegations are probably already communicated, whether formally or informally, to this point prior to July 20th, right? When it's called out within the 8K. I think they know exactly what they were looking at. There's probably already prepared statements and rebuttals for this. And that would be my assumption, would be that the legal fees are all associated with those responses and in cooperation with that investigation, which has been laid out again within each one of the quarterly findings since Q3 2021.
Hey, Curtis, can I just give a little bit of not pushback, but a question? I mean, can we make that leap that it was for legal fees as opposed to, we know that Meta has a lot of patent work. Patent lawyers ain't cheap. Could it have been for something else, or based on the timing, it's pretty conclusive that that's what it was?
No, I'm not guessing. It literally calls it out as a footnote.
It does.
As to the actual increase in fees is, I was reading verbatim. From this latest quarterly findings, the reduction in general and administrative expenses of $4.4 million for the 3 months ending in March 31st, 2023, as compared to the same period of 2022, is primarily due to a $4 million reduction in professional fees, mainly due to the reduced legal costs associated with the SEC investigation and lawsuit.
Okay, perfect. I didn't realize you were reading it verbatim. So, okay, thank you. I'm glad for that clarity.
Yeah, you're welcome. I'd have to find the exact quarterly. I think it actually increased 2 consecutive quarters with legal fees associated with this SEC investigation. But what I can't speak to, because it's baked in, is what I was referencing, is how much of the legal fees are associated from like a line item standpoint to the SEC investigation versus the class action, right? There's no differentiating that, but the whole point of them calling attention to that first and foremost as priority, as like it's explicitly called out, you could assume those legal fees are associated to some level of work that was done. So I would imagine that they already have a planned rebuttal.
Thank you, Curtis. Asian V, go ahead.
Hey, good evening, everybody. Thanks, Anna, for the space. I'm glad Curtis is on here. I finally get to talk to him. But I have 2 denials for FOIA. And can Curtis, can you kind of give me a little bit of insight on what I should respond to in terms of appealing the denials with the 74 whatever? yeah, can you give me something like, something to say to them, like what's my argument of appeal? Show me proof, because obviously they didn't show proof. They just put that with everybody's denial, right? The 74 or something. Um, um, what do I ask them, or because I do have a contact in the SEC/FOIA department in the SEC that I have been communicating with in the past. Um, so what would I ask her? If you can give me some advice, that'd be great. Thanks.
Yeah, that's a great question. So I think it's probably premature right now because this Wells notice was just provided on July 20th, and obviously we're just becoming aware of it today as the 8K was filed. But I think if you have normal dialogue with this contact, I would acknowledge your awareness of the Wells notice and of what appears to be the conclusion of the investigation, and that you're anticipating some level of conclusion of this within, I don't know, some reasonable time frame. I don't know what that is yet, because I imagine that the parties are going to rebut, but that upon completion or conclusion of this investigation and any circumstances that result of civil charges, will that clear the runway for your requests, your various requests? Because that's what number 2 big D. I'm just going to reference you as that from now on. Number 2 big D. That's what it's kind of a generic response, so they don't openly disclose that there is or there is not an investigation, just that there could be. And now we know, and we already did before, but we know specifically that there's the conclusion of the only known SEC investigation. And so it would seem that does clear the runway upon its conclusion. So I wouldn't file an appeal yet, but if you have normal dialogue with that contact, I would just start that process. And if you wouldn't mind sharing your findings and communication without airing out or hanging out your contact to dry, right?
No,
But
sure, Curtis. I have you in the DMs, and
yep.
whatever you just said, please, I'll keep in contact with you. We talk in the DMs for that Zoom meeting. But yeah, so I will I will keep in touch with you and call my contact, and I'll keep that in the background. I won't air it in public in the spaces, but I'll contact you and see what you can do to help me say in my response and my experience with my contact with that FOIA person. Okay, thank you.
Yeah, great question. Thank you. We'll be in touch.
Yes, sir. Thank you very much, Curtis. Thank you, Anna, for the bye.
Thank you, Agent V. I know, Halia, you have your hand up, but I saw Smokey waving his hand. Did you want to chime in on this,
I
Smokey?
was just saying good night. I'm headed off to bed. I have work in the morning.
Okay, well, good night. Thank you for coming up and spending some time with us. It was great hearing from
No
you.
problem. Thanks for having me speak. Thanks, guys. Good night.
Thanks, Smokey. Have a
You
great
too.
night. Halia, love that. Go ahead.
Yeah, I was wondering, since this the way this um what's going on right now, how it kind of started before the MMTLP, could it be possible that during the course of the investigation, somebody stumbled along and decided to start stealing, and it happened to be the one that they were investigating, and then they just let it play out, and that's why they didn't stop it, so they can continue investigating the person they caught stealing? Because with it not supposed to trade and all this other hairy stuff, like you said, why did they let it trade? And then you get the issuers saying, why is it trading? you know if you put all that together, if they really follow the whole timeline, there's some bad actors in there. And from the sound of it, this shouldn't have never traded, like it shouldn't have never traded.
I don't think they could allow defrauding investors in an effort to. I mean, I don't know. I can't see them allowing a complete defrauding of tens of thousands of people in an effort to weed out nefarious actors. I think they already know, and I think they could have figured that out already. But I don't know, putting everybody in financial harm, which could lead to any number of serious outcomes, including death and destruction. I'm not sure that they would have a foot to stand on to do that, but just my opinion.
It looks like we're the results because they knew.
Thank you, Halia. Thank you, number 2, Big Daddy Pencil. I think it was Marduk and then number
Hey,
2, Ben.
can we have Mrs. Pencil Sharpener come and say hi?
Yeah.
Hang on, Marduk. Come on.
We haven't heard from her in a while.
Hola, amigo.
Hello, how are you?
I'm doing well, thanks.
So your thoughts on this new name that Mr. Big Daddy Pencil has now?
Well, it's true.
Okay, Marduk, you're
Hey,
next.
Marduk,
Thank
you're
you
up.
very much.
Am I up or are you?
TMI.
Oh my. It's nice to know that you really exist, though, my lady, because this is the first time I've actually heard your voice. So nice to meet you.
Oh, wait. Hey. Oh, yeah,
So
sorry. I
this,
didn't know I had muted.
go ahead.
Thank you, Junk.
Nice to meet you, Pencil Sharpener.
Mrs. Pencil Sharpener.
That's Mrs. Pencil Sharpener to you.
Anyway, it's all good. Lighten this conversation a bit.
Yep.
So everybody knows that Twitter is now called X, right? Like Twitter doesn't, like Twitter's not
Yep.
Twitter anymore. Yep. Okay. So I just
X.com.
want to point this out because I think it's awesome. We've gone from Twitter Spaces to Spaces X.
I thought I heard a rumor about the X thing today.
No joke. Welcome to Spaces X. I love it. That was it.
Thanks, Marduk. Okay, guys, it's about getting my bedtime. So I'm going to shut the space down soon. If anyone wants to take a mic or has anything to say, now's the time. So if anyone has any more questions or thoughts.
I came in late. I didn't know I didn't know anything about this. I was working. What was the title? Is Mark Basile discusses the Wells notice? What can somebody sum that up in a few words? What he had to say about it? I'm just curious. What since that was the lead in here.
Yeah, I think he was saying that this could be an opening for discovery, that we should not panic. So I think, but then it was brought up later in the space that this was, that this was a subpoena from back in 2021. Not that that would make us panic, but it's just that, what was brought up in the space is that this is not a time to let up, that it could be, um, this could be a setback a little bit for us at Congress, right? Because the timing of this, right? We know we have a lot of traction at Congress, and that we're getting close to hopefully them making some kind of statement or pushing forth to getting us some kind of, fact finding where we can see the numbers. So it's just a time for us, guys. Like what 100 put out tonight is, I'm going to work on it in a bit, is try to, put together my email and my phone conversation for tomorrow. And I suggest that we all do that, is to put our thought into how we're going to approach Congress with this. And, that the SEC has done something like this before, where they've gone after the issuers instead of the short sellers that created this problem. So we just want to make sure that this isn't like for deflection, so that our cry for help is then trying to be pushed under the rug. So we just have to continue to approach Congress, and nothing has really changed. So I think if anything, we have to just amp up our efforts.
Yeah,
So
it's a know the difference between the two things. Where there's two issues here. This is not related. Yeah, well, it's all interrelated, but this has nothing to do with the fraud perpetrated on us from the get go. So this is something. This is something else that had started before this ever went to trading, and before the U3 halt. And this is you just got to know to separate these two things in a conversation.
Yeah, and I think it was a really good point that was brought up. If they knew that there was an issue with this, then why would they put it back up for trading? And for as MMTLP, and that, and if Brda and Palikaris weren't the ones to get that, then they need to look into the people who actually got MMTLP trading, and that's what we need to, express to Congress. So, yeah. All right, I think it was Savvy and then Marduk.
Actually, it was Marduk first. Go ahead, Marduk.
Go ahead,
Yeah,
Savvy.
just one last quick thing because Pencil brought up Mark Basile, so I just immediately started thinking lawyers speak on the Wells notice. Just a friendly reminder, tomorrow at 12:30, Richard Hoffman will be doing a live stream with JR. So just jot that down because I think it will benefit a lot of us to actually, take the time to sit in and listen to what they have to say about it. So, cheers. Sorry, that's 12:30 Eastern. Yeah. Okay.
Yeah, 12:30 Eastern. And I'll have that posted in the space in the morning as well. And then also, just to let you guys know, Mark indicated he might pop in the space in the morning to have a further discussion. So I'll check with him in the morning on that. But Pencil, I want to let you know that I think Mark's position was also that right now we don't know what they're going to do. We don't know if they are going to actually file charges. We just don't know yet. So Mark wants us to stay focused on the task at hand until we do know for certain. And so, let's not make leaps and bounds there. We don't want to pull a muscle, but let's keep doing what we're doing. And as I have said throughout this is, no matter what George or John or Meta or anyone may have done or not done, we will find out at least what they're accused of, if they are accused of anything. But it does not change the fact that we are oversold. We know we are. They've already confirmed that we are. FINRA confirmed that there were open short positions. Cromwell confirmed it. So we know that we are oversold. And neither John nor George made those counterfeit shares, and they didn't sell them. And they certainly weren't the one that U3 halted this in order to give us a settlement issue. And so we just need to stay focused on the fact that at the very core of this, we were either defrauded with counterfeit shares or we weren't. And we need to continue to push Congress to get us an aggregated audited share count.
Make no mistake that this investigation that they started back in 21, that everything that has happened, they're well aware from the beginning, from before the merger. This information would have come out in that investigation. So they know this is oversold, and they know when this started, and I'm sure they know by approximately how much. I mean, they know by how much because they've pulled the blue sheets, et cetera, and they know this has started before the merger, long before.
Well, and also if you look at it this way, the assets are there. Any quote unquote, well, first of all, pumping a stock is not illegal. Pumping it and then dumping it is illegal. And as far as we know, there was no dumping at this point. As far as we know, they may present evidence otherwise. But the assets are there. And, those short positions existed in Torch before the merger even happened.
That's what
and so the fraud happened before the merger, if that is indeed the focus of this investigation, before that even happened. And so, but and Mark did say, as Anna said, it may lead to further discovery if they're accused of certain situations around the merger. Well, then maybe pulling, subpoenaing, getting discovery on those blue sheets for Torch might be relevant. So we never know. Let's look for the silver linings, but let's be prepared for all the possibilities.
Do we know?
But continue to stay
focused. Is there
focused.
a way to know if anybody else has been served any kind of a notice or in the back? Do we?
No,
You know what I'm saying? Is there any news
no.
of?
Wells notice these type of notices are confidential,
All right.
so we
Yeah,
wouldn't have
but
known
they
about
just
it except that the
gotcha. I'm just curious in the market if anybody, if has there been any notices in the last several days or today of, or maybe tomorrow of somebody being charged or any. We just keep an eye open. Not with regard to
Well, if it
not
was
with regards not with
associated,
regards to metamaterials or Torchlight, but with with somebody on the other side of this.
no, not that I've seen. I'm assuming you mean the people who got this trading or who
Yeah,
we
exactly.
think
Yeah,
got this trading. But
or
no,
over
I have
or
not
yeah,
seen
or
any.
prior
No, I have not seen
anybody
any
that's
news.
oversold it prior to, because during this investigation they would have learned a, a lot, and so there may be charges coming just because they were served a Wells notice. I'm just saying, I'm just throwing this out there. It doesn't mean that they aren't going to charge somebody on the other side if they've found fraud. I mean, it's not to say, and I'm not saying this is going to happen, but it's not to say they could charge both sides. There could be charges coming out, not charge, well, accusations or whatever they happen to come out if they were to do something with metamaterials or John Brda Palikaris. You know, it's not at the same time they could be charging other people on the other side. Is that not true or a possibility?
I honestly, we have no idea of knowing until those enforcement actions are filed. So Wells notices are confidential, and the only reason that we know is because Meta did an 8K filing.
Gotcha.
But the enforcement action is public record. So
Yes,
this is
absolutely.
private. Enforcement is public record. So stay tuned.
So Reed, just a quick question. So does that mean that Meta voluntarily disclosed the Wells notice?
Uh-huh. Yes.
Okay. Yeah, that's what I thought. That's what I thought. Okay. Awesome,
They
Anna. I know it's
did,
late,
but
so I'm gonna step down. Anna, busy, junk. Thank you so very much for holding everything together. Curtis, 100. Everybody being here is the reason we're still here. Okay? So thank you for staying committed and sticking together. And when stuff like this comes out, we squash it. We talk about it, we work it out, and we make sense of it. And you know what? All the people out there want to call us cultists and say that we're just, you know, feeding into our own hopium. Let them talk all the crap they want. I don't care. I'm over it. I'm moving on. I got things to do. Thank you. Have a good night. Love you guys.
Take care.
let me say really quick, Mark, before you go, though, is though they filed the 8K, they were not required to file it, not necessarily volunteer, meaning it is a material and substantial, could have a material and substantial effect on their stock and their shareholders. And so it could be argued that they had to, even though technically the SEC doesn't require them to do it. So wasn't 100% volunteer. I don't think they could sit on this. I'll have to ask Mark what exactly that was that he cited, but I'll see if I can get that answer for tomorrow morning.
So I guess we have a difference of opinion between two legal attorneys, because Richard said that because George P was the CEO, it is required.
Maybe that was it, actually. I could be mistaken. Sorry, it's been a long day, guys. Yeah.
It's all right. It doesn't matter. It doesn't matter. It just doesn't.
No, it is what it is. So
it is what it is. But yeah, you know what? Personally, I just wanted to say thank you to Anna and Busy for hosting the space, and Smokey and Curtis. You guys are rocks. I really do appreciate you sharing not just your personal perspective on things, but just being here and supporting everything as we move forward. I know, Smokey, you're not always in these spaces, but I appreciate you for what you do as well. So thank you.
Thank you, 100. And thank you so much for always being here for us, and Curtis and Savvy, Busy, everyone. I appreciate it, Smokey. This has been a great space tonight. Halya, go ahead.
Um, it's a two-part question. So, they're looking at as far as trouble, couple $1 million fine. George might have to step down, something like that.
No one knows. Gotta wait.
Okay. And then the other part was, um, oh, you guys took so long. I might have to get back with you. I think I'm getting it. I got a brain fart. Hold on. Hold the mic. Oh, oh, here you go. So George Palikaris is the head guy, and that's why he had to be notified. But who is John Brda in this scenario? He was only a lower level guy and not really the guy in charge.
Well,
No, John was CEO of Torch,
yeah,
and Torch is named in the Wells notice.
I mean, what was he at Torch?
He
he's
was
the
the
CEO.
CEO.
Yeah, John was the CEO of Torch, and George, of course, was the CEO of Meta.
So his old paperwork, what was his job then?
Chief Executive Officer.
CEO? Oh, okay.
I don't understand
Are
what's.
you asking after the merger? How yet?
No,
Is that what?
before the merger, I'm thinking because I thought John Brda was like not really in charge, but under the guy in charge.
No,
But
John Brda was CEO of Torchlight Energies. George Palikaris was CEO of Meta. When they merged, I believe John joined the board of directors. Curtis, is that correct?
No, I think
Of the new Meta materials?
No, I think he resigned as officer. Within there's a filing immediately subsequent to the merger completion, and he stayed on as a consultant.
Oh, a consultant. Okay.
Yeah.
so
And
where
then, of
How
where
you
course,
was
George
McCabe?
Palikaris is CEO.
you're thinking about McCabe in this deal? That's the equation that you're having a problem with.
Well, I don't have a problem with anybody. I'm just
No,
wondering
no.
because
You were asking.
because they didn't ask for McCabe, they asked for John, and I'm thinking is well if McCabe was over John, why didn't they ask for McCabe instead of John or something
McCabe
like that?
wasn't over John. John was CEO.
That's what I'm saying. That's
Oh,
where your
okay.
mix-up is, Halia. That's all. You're thinking McCabe's the big man, and back in the day before the merger. That's I caught on to that early on what you were talking about. That's all. You're not seeing John Brda was the CEO, Chief Executive Officer of Torchlight.
But when the old information that they used of his, what position was that?
CEO.
For the third time.
No, he's asking when the market makers got this training and
When the
on
forgery
the
was committed.
supposed whatever 211 F6 whatever form wasn't
Oh, I thought
filed out.
he's asking what was he when okay, the information they used was from when he was CEO back in the day. Is that what you're asking, Halia?
Yes, exactly. Which that wouldn't even qualify him to be standing at the counter to do such an action.
Well, here's the problem. We've never seen the paperwork. We've only heard what John said about the paperwork. They actually won't produce the paperwork, so we don't really know what was used. We just know it was outdated.
Yeah, I mean severely outdated, if I remember rightly. I mean it's
12 years, I believe.
severely outdated, right? Thanks for everybody.
Well,
I
that's all.
appreciate it. Have a good night.
All right, guys, I'm going to shut the space down. I appreciate everyone coming tonight and taking part, and I will look forward to Savvy Space in the morning, and hopefully Basil will come on and discuss this some more, and then we look forward to Richard Hoffman's space tomorrow, and we'll just get back at it. We have a lot to do this week, right? We have to ramp up our action, so let's just get a good night's rest, and we'll be back at it tomorrow. Thank you, Busy and Savvy, for hosting with me, and 100 and Curtis for being up here at the mic and answering questions. Just thank you, everyone.
It was a great space call. Thank you, Anna, for hosting it.
Thank you, Busy. Y'all have a great night.
Thank you.
Thank you.
Good night, guys.
Good night.